brought to the most, even if it is a criminal case, most of the time I just like negotiating and negotiating. So that's why I'm not very good in negotiation. So let me say, that's why I'm not very good in negotiation. But in this experience that I had with the Islamic, other religions, and religions. So I'm very, very happy and impressed that I was also go and research other religions to learn more about this kind of issue of settlement. Then I also learned how to how to grab the difficult resolution between parties when the closing and then though that in fact I have a thing I have a pending case which is happening between a company and a local government. So it's a serious issue, but I was intending to go into mediation because it's an issue that was almost 50 million naira and been for those. So in fact, the local government, if you have to go with the investigation, the local government will not substitute the agreement and because the kind of agreement the way is a terrible one because there is not even the resolution clause there in the agreement. So with this one, I will do what I got from Shati'S to go and settle back that case.
So I remember that's why it's very important for the judges. Magistrate all very important area. Because I remember having a matter in the side. In a it doesn't mean that this matter is don't take any all the people find the matter how to be claiming and directing. So at the end of the day, I think I was representing the defendant. So when we finally went for the magistrate, so we went for at the end of it, we discovered that all what we did was apology and mutual just apology. So you see the stress she made, or what she needed to do. And the moment they apologize, you can see it's bad. So let's just go.
I think because of our home
I think I also keep some.
Sorry.
Thank you for that. Before I complete one thing. Okay.
Now this is very such. This is very
I tried to make some so you kind of manage many of this nature I did. Thank you. It was inheritance matter. The lady was for the She don't really know what she wants, whether mediation or what she wants cannot be but that's so we want to pretend that that's not what she wants. So let's not mention. So what we did, we invited people everyone. It can't be central without all this because people expect something. So when Mr. Barrister so when we start with 5 minutes, now you're not really ready. So I told you that. When I told you that, I asked them if they are okay with it. The respondent said he wants us to meet at his house. Exactly. Popular session. So you know I'm a young so I have very so I don't consult it. I said this is why as far as I recall. So they are showing me that I should not based on the schedule in my time, it's not working. So when I went, we have a quality sleep and it is part of everything. So they finally resolved check property based on their native law. And at the end of it, it was a very important and the bishop was so I get the benefit of that. So one benefit is at the end of it, so what I'm trying to say is family sometimes, you know, what to give them individual friend. So I think let's
Projects.
Yeah.
Also, my counselor. One of them, I have now how and I've learned about how are they going to know my room? Then you know how to deal with this on their change. In fact, things I have a couple now, so apart from you, man doesn't go into all the letter, with this other family, I will now sometimes one of the things we used to do before, we tend to discuss information that we receive from some parties with other people who don't believe that it's possible. At least I now understand that before I can relate what the wife of my husband has told me in our private session, I would not tell anything except I said that possible. Because sometimes you just want a source and then you come out because people this is why this is what they need. Now I've learned that I should more complication. Particularly information I think about this. And that aspect is sometimes to be very thinking, very now. of the conflict. And when they talk to you, you know, sometimes you come and sometimes you don't care where to people see. And now on the fact that the environment, very important, you know, it's an important environment that really be comfortable what of them able to stop. And that I should not be biased. I don't neutral. They should be doing more. But it's in their business. They are the ones who do more of the talking. Mine is just what I have seen chaos. Even the talk about you see us trying to impose decisions or what we feel to be done. Okay, that is why we are seeing talking in certain people. Because we are not doing it. They will be the knowledge of the CPR. I think I am better able to assist even the board on how to handle these issues. The aim is not just to say this one is the winner, this one is the loser. Let the aim be that at the end of the day, the peace that was existing between parties will be maintained. And I have learned a lot, and I want to wish Shati best of luck. You should improve what you are doing. And that there are some lessons we learned here, some mistakes. They were too fast for our understanding. So they were too fast. Like, so I want to suggest that there are certain topics that we are not giving adequate time. The Center for Knowledge, that makes it comes to this. She was a bit faster. We didn't get what she was saying. We understand her education better. She was a bit faster. So what is, I think I better message now. And then anywhere education is I will put it now as a professional, competition or competition, and then I will try as much as possible to be neutral. How good and this is the reason why mediation is called up.
Okay, so let me make a suggestion. You know, when you start about church, I remember another recent mediation with a marriage of 10 years. We understood at the end of the mediation, the couple still loved themselves, but the problem was church was not really settling the dispute properly. Both their church in Kaduna and the church in Zaria, because the man is working in Zaria. So even family too, they're also mediating as church was mediating, but we're not really hitting the matter very well. The woman was always at a disadvantage because you know the pastors will say, the Bible say, woman submit. You know, woman is always at a disadvantage. People come when they have a quiet. When your husband is talking, don't talk. Shut up. People, your husband is trying. People are like women. Don't have a woman like that. There are women that your husband was like, fight there. But what do you give this one there? You see the way they want she said she's tired. The family has been resolving and resolving. Churches, both Kaduna and Zaria, have been resolving and resolving. So at the end of it, when she came to us, she told us all and we understood that there are probably misunderstanding, lack of communication, proper communication, then trust. Because the husband has a friend, a female friend that she doesn't like their relationship. She has a friend that the husband does not like their relationship. So, but at the end of it, you will see that they are really doing it innocently. They were doing it innocently, not when they were hurting each other. And in the past, they were doing their stuff more harm. So at the end of it, after the mediation, we spoke at length with the wife, spoke at length with the husband, tried to strike a balance between them. But at the end of it, Mama was very brave because she was insisting. Oh yeah, take this matter to court, so take this matter to court. Say this thing I don't like. So I think the only thing we got on her to advise her to implement that once we go to court, because the law grant us both to the people. So we ask us, have we explored settlement? How we cannot lie to court. So let's try and explore, and at the end of it, we try to work. And I think what satisfies is let's draft and agreement. Then your husband said it's okay with it. If not an agreement for satisfied, they won't draft this. That's the power of mediation.
Morning. My name is Frida Samani. I'm court registrar with Kaduna State. I really appreciate this training, Shati, because I've learned a lot of things on settling news matters that come before the court, which must not go through litigation. Even at the registry level, there's a possibility for one able to settle in cases between parties. So the steps taken and given on ethics, personality, threats, and other steps taken in order to settle matters have really helped me as to knowing the steps to take when settling issues even before going for litigation. And I really appreciate it because I got to know that it's supposed to be done in private. It's a voluntary kind of a thing. You don't impose ideas, suggestions, or anything on parties. Let it be a voluntary kind of a thing of which they accepting this what they want to be done, and you as a facilitator is just to put them through the process on how to settle matters. Thank you so much.
Please, we have just one minute. 1 minute to summarize what we learned so far, or what just stood out for us in this training. Just what stood out, so that we can all learn from what stood out for you. Okay, 1 minute is enough.
My name is Shati'S, and I'm happy to be in this training at Shati, because I learned a lot of things. Because before I thought about mediation is different from what I was taught here. I was much led by a lot of things. Like for example, I know personality types. And I also took on my own personality, which before I don't even think about it. So, and I know how to approach friend dispute in mediation process.
Next question.
Good morning, House. My name is Janet Aubundalima. I'm a legal practitioner. Happy to be here. I learned so many things yesterday in my first day of coming, and I learned things like emotional intelligence and how it is better to have emotional intelligence as against the IQ. I also learned about the 4 personality types and their differences and how to go about handling disputes in mediation by taking note of the kind of personality before me. I also got the opportunity to enter into simulation, and I learned so many things like the opening, the introduction, opening statement, yes. And then I noticed that inside the opening statement, there are so many things, like you tend to build the confidence of the person that is before you, and how you disclose the process. And I realized that in the process, there's a need for confidentiality. There's even a need for you to show the person that it's a voluntary session, and then they can pull out at any time they want to pull out. And then there's a need for them to write down agreements and all other things like that, so that they will not come and relate later on what they have agreed upon. So I've learned, but because there's no time to say much, I want to just pause here and say thank you to the House for the training.
My name is Muhammad Adamishu.
Okay, I see. If you can wrap up within 1 minute, if less than that, we have lots of activities.
I love to you to contest the time we are having. But in addition to what my colleague says, I learned how the global is being attempted to threat the society. Because through this course, I learned how this book is being resolved globally. Because we have to have a presentation from the all international community that can give us a hint how the method and techniques applied in different society in industrial with the emphasis with this heterogenical society we are in Nigeria. So that's what I can say in a nutshell. Thank you.
At this point, I would want us now to start with our opening statement. For those that were able to give maybe what stood out for them, go on subsequently. But now we commence with the opening statement. So we start one after the other. And the opening statement will be 3 minutes. At most 5 minutes. At most 5 minutes. 5 minutes. 5 minutes. Please let's take the time. 5 minutes. So let's start. You can decide if you can stand. You can stand to give us your opening statement. If you prefer sitting, you know, mediation is a comfortable process. Even in the real life scenario, we do it sitting. So anyone that is more convenient for you, just choose it and give it to us.
Okay, this is my opening statement. Good afternoon. Welcome to
Please excuse me. You will not read from any material. That one instruction, I will not our reading. We want to make sure yes. And mediation of statement, perfectionality is not our point. It's not going to have real ingredients. It's not the elements, not have the elements in it. So that's the reason why we don't want to read poverty. We want to be sure that we understood those elements in our opening statement. Even when you were all speaking and telling us what really stood out for you, I could hear a lot of elements coming from you. So it's already in you. So just trust yourself, be able to material and give us what you have. No. Without material. We are not here to give you 0 or 100. We just want to yes. Thank you very much.
Okay. Good morning. Welcome to this first session of mediation proceeding. My name is Emmanuel Dr. I am your mediator. I am a certified mediator, trained by the Settlement House ADR Training Institute. I would want each of you to, I would prefer to be called Mr. Samela throughout this proceeding. And I would want each of you to take your turns to introduce yourself. Thank you for this introduction. And I would want you to also tell us the name you want to go by in the course of this proceeding. Thank you. Okay, I appreciate the fact that you chose to explore the path of mediation in seeking settlement and the resolution of your disputes. And I understand that you have already signed the mediation agreement, and I will take some time to explain one or two things from there so that we can have some understanding about the process. There's some guidelines how we will move. I want you to understand that the process is it's going to be confidential and it's going to be private, but the room where we are is subject to will be used only by us. No other person have access here. There's no CCTV here. There's no audio recording here. And whatever we discuss here will just be between the three of us. So you feel free to express yourself, feel free to state what you have in mind as you seek solution to this issue. I would want you to understand also that you are in charge of the proceedings here. My role is just to act as a facilitator to guide you towards reaching a mutual and amicable resolution of the issue. At the end of whatever notes I take here in the course of this proceeding, will just be as a guide for me to help facilitate the proceeding better. And at the end of the proceeding, the notes will be spread. And the agreement we reach at the end, the agreement you reach at the end of the proceeding will be put into writing, right over to you so that you will understand and agree that yes, that is your agreement. Part of some of the guidelines I want us to understand also here is that we need to set some guidelines so that it will guide us on some things that we do. For instance, each person will take turns to talk without the interruption from any other person. But everyone is going to give the time to talk. And secondly, I want us to speak to each other with respect. No shouting, no any kind of thing that will distract another person. I don't know if you have any question to ask before we proceed. Okay, thank you. We shall start with this, your statements, your opening statements. You each tell us what you think is the dispute that you want to hear from both of you before we proceed. I'm not going to pick on any of you to start. Either of you may start. So, thank you.
This is a beautiful opening statement. Thank you for deciding to plan a beautiful. I hope we are noting the things you committed and the things you did not emphasize on. I don't know whether we are omitting to do that. Are we omitting to do that? Now to take notes. Are we okay? Let me make it a positive and bring it to the positive way. Are we taking notes of what he's doing? Because at the end of it, you will give each other the room to criticize him. But for now, I think everybody will go now. All right, everybody will give opening statement. Then the criticism will be general, not individual. Opening statement.
It's different. It's different.
Ladies and gentlemen,
Let's just leave it.
session. My name is Dr. Salman. The sacrifice, mediator, prayed by the settlement house area in the institute. Thank you for choosing me as your mediator. I would prefer you address me as your mediator. Please let me meet Hubert. Having introduced us, I want you to give me the preference of how you may want me to address you. I would want to encourage you that you have agreed to submit yourself to this process of mediation voluntarily. I want to propose to you this fact that this session is confidential, and I shall hear both of you please on the discord you have at hand. It is your person. My role here is to assist you and run a amicable resolution of the dispute between you without getting the favor of either of you. So I am like the moderator of this process. I shall go about solving this problem by first listening to the person who brought the complaint first, and then subsequently the response of the other party. I shall give you the opportunity to do that now while thanking you for submitting to this process. Having listened to the complaint of the complainant hearing, then the response of the other party hearing, I have distilled, or rather set this as an agenda for this session. Since this is a matrimonial cause, issues are set for resolution is one, whether you would intend the matrimonial cause or problem between you, whether the marriage should be resolved amicably. Secondly, custody of the children, and thirdly, alimony and or maintenance. Since you are all here out of your own volition, we shall handle these issues at severity. Firstly, we take the issue of dissolution of marriage, and as they are there. At the end of the session, we are going to resolve and to put your resolutions form of draft towards enforcement of sin. However, if you wish to strictly adhere to your resolutions, as you may agree at the end of this session, I shall oblige you that, should you wish that enforcement is done by the court, we shall take the necessary step while your terms of resolution in the court towards enforcement of sin. Gentlemen, ladies and gentlemen, thank you for being there, and thank you for submitting to this very wonderful process of mediation where it's less expensive, saves relationships, other men relationships, and then confidential. Thank you.
Thank you very much. Please, a round of applause. I was just informed. Please pardon me, the first two persons. I was just informed that when you are Giving your opening statement. Curious. Yes, who sits here? Yes, who sits? The camera. Is it not? Is it okay? The camera. Not sit here. So anyone that once it's your turn, at least it's more practical. You'll be looking at us as your client. Yes. As the party, yes, then you pick the party. So mediator, it's your time.
Good morning, gentlemen. You are welcome to this session. I will commence by introducing myself. In fact, you addressing me as I choose the new project. I also want to tell you how you want me to address in the students in this process. One good thing about the question, I take note of volunteer. The first party will do it. I am here as the assist you go. Also wants to individual yourself. Thank you for doing so. Yes, I stated earlier. Every human activity rules governance on here we should have respect to them together. Going to be one outside order. Meaning anyone who is going to talk should be allowed to talk for the next person. Purpose of our coming here is to resolve issues between you and the other. We're going to the mediation. I'm going to the neutral. Time I'm going to abortion to Mr. A. Also going to abortion center Mr. B. Show you that only here assist, not to control the process. I don't want to control the process. Feel free. When there will be a need for us go into focus, and if there is anything that you really want to share with other party, see you in the camera so that you feel free to express yourself. What I will come to the point. This will tell you. There are other facilities too. We have facilities like the restroom. If you feel you want to use yourself, feel free to let me know so that you go there and use yourself. At the end of it, we would draft or rather distill the main issues for determination. Then that will be done by me. Then I will now acquire information from you so that you feel free and tell me why you are here and what is the goal of the intention, so that I will allow you and assist you to make yourself open, present the facts. Then we will now draft the terms, settlement or agreement. If you so wish, at the end of it, such terms of agreement will be filed at the court. Adoption from consent judgment. However, it's going to be subject to free will. Remember, like I said, we are going to maintain Not to maintain neutrality. Anything done here is confidential. You are going to self-determine because you are the one to control the session, not me. Thank you. I believe you must have signed mediation agreement before we commence, before even coming to mediation. That is very, very fundamental. Thank you for giving me time since you arrive at amicable resolution. Thank you once for guide us process of this mediation.
I think the next person. Next person from yes, he's going this way. Please let's be careful with our time because once this statement is too long, the party should be tired. Once an opening statement is too long, parties will be tired. So as a mediator, try to put necessary elements in your opening statement so that it will be more than 5 minutes. If you can get 3 minutes, but if you cannot summarize it, because opening statement sets the pace and it helps you to be in control. Because once rules of engagement has been given, the parties will not want to go contrary to that. So it will help you to control the procedure. So 5 minutes is the highest you can go for. You're going to get tired. So please, sir, 5 minutes.
Good morning. Welcome to this education. I'm quite trained mediator but these 13 members media opportunities. Thank you for choosing vision you are listening. I would like to address me as this person. I also want to know how you want to address this person. Thank you. The essence of this proceeding is to not just evaluate this proceeding. The essence of this is to help you reach an agreeable settlement in this dispute. The disputes or you are free to express your interest and this can help us reach an agreeable resolution. This proceeding, I would like to make it known that this proceeding is what is being said here, starts here and ends here. No one is permitted to share what is being discussed here. If not, you put that here. So feel free, say what you have in mind, so that it will help us reach an agreeable settlement. I also want to recommend you that this process is yours. It's you that will drive the process. I am only to help you reach this settlement. Thank you for choosing mission to settle this. Again, it's going to be a win-win for all of us, so that our relationship will continue. What wrong has been done to the other way. I think they can, if continue the relationship, they will both avoid it. Thank you for this opportunity. Doesn't need to be on your paper. Thank you.
Mr. Ramaphosa, a very beautiful opening statement.
Morning. Morning, welcome. So, Mediation proceedings. My name is Barbara. Mediation. You can call me Mr. Bernard. I am a trained certified little held by Shati'S Media Training Institute. You may also do this process. You can tell me how you want to progress. Before we start, what to confirm agreement to be yet. We have done that. Good. I also want to confirm whether you have complete authority to participate in this initial session. Let me quickly add that mediation is a voluntary thing. It is also confidential. And that's how we, as far as possible, be neutral. We will drive the process. We will want to present your issues. Mine is just to assist you to arrive at able settlement of the issue. We're going to ignite communication between you and each suspected to put his own interests. If at the end of the day you are able to settle, no matter I have the money. Then, just like I have reiterated that I'm going to be neutral, but we want to drive the process. I also want to request that you present your issues very brief, precise, to the understanding of the other party, even myself. And at this juncture, I want to welcome the complainant to briefly state reason, the main substance of this complaint. Then the defendant also have time also see the wrong part of the story. Thank you. We are almost welcome.
Please, a round of applause. Please, I hope you are noting everybody's strength and weakness in their opening statement. Because when you note it well, at least you understand the element. Thank you.
Good morning. You all this session. My name is somebody. I'll be prepared to be addressed as reader during these proceedings. I want to thank you for choosing mediation to solve the disputes that is standing for us today. I also want you to introduce yourselves and to let me know the names you want to address during these proceedings. Actually, the mediation process is voluntary. It's a process whereby you, as the parties involved, are allowed to take up the matter before us, of which at the end of it all, you are the ones in charge of subject matter. Also, it's confidential in the sense that whatever is being discussed, be it in a joint session or a private session, the information skipping at that point in time will not be disclosed to the non-party or non-participant in this matter. Also, I want you to note that there will be partiality or preferential treatment given to any party in this matter, because it's something that has to be orderly done and not being taking sides in this situation that we're in. I also want you as parties to understand that we have rules guiding this process in which parties cannot speak at the same time. We give room for one to talk. When you're done, then the other will pick up. And also, you have to be polite to participants. You also have to be respectful to participants. And I want to, if you have anything to add on to the rules, even as this proceedings is going, you are allowed to. I also want to say thank you for using this video mediation to resolve your issue, and hope that will come up with a very good result in resolving the matter before us. Thank you, boys.
Good morning to you all. My name is Hadiza Muhammad Harami. In mediation in this process, I would like to be addressed as Hadiza or Ms. Hadiza in today's mediation. And before I proceed, I would like you to introduce yourself and how I will address you in today's mediation. And also, thank you for choosing mediation to be your dispute resolution today. And I hope you have the authority to go through the mediation process. And as well, you know what mediation means. Even though I hope you also sign an agreement for resolving through mediation. And I will also have to inform you what is mediation, even though I believe you know what is mediation. Mediation is a voluntary process. And every mediation is unique, and this is yours. And I'm here as a mediator, not as a judge or attorney. I'm only here to facilitate your dispute in this process and to just be an intermediary to help you resolve any tension. And we also have a rule in mediation process, whereby if one person is struggling, they have to be given equal time and there will not be any interruption until after he finish, the other party will take over. And whatever we discuss here, it is confidential to both of us. It is confidential. You are not supposed to record or video record any of this process. And anything you share with me private or even within the two of us, I'm going to keep it confidential. And I cannot be called as a witness in this mediation process unless otherwise asked by the judge. That is the only exception. And I welcome you once again. And thank you for a very beautiful opening.
Good morning. Good morning, all. So, my name is Muhammad Abdul Expert. I think a certified mediator with a Shati'S area inputs training. I have an experience of resolving input between individual and private organizations and other organizations, including the government, agencies, and what have you. So I have an experience of composure of entertaining many disputes and resolving it amicably. So during this session, I would like you to address me as FPHU. This process that we are to undergo is a voluntary process that I want every one of you to feel free and speak the sincere mind of what confronts between yourself. And first of all, I would like each one of you to introduce themselves by what we call opening statement, while we just briefly check your profile and also narrate the sincere mind of what confronts between yourself in a focused manner. And I would also expect you to respect the rules guiding these sessions, that when either of you is narrating his one item, he has to be listed from the beginning to the end without interruptions, and also a mild way of expression, so that we shouldn't feel aggressive or irritate another. So we should be that it is a private session, that all what we discuss here will not be taken to the public unless it was being agreed upon by the participants, that matter should be taken to the public, particularly when we draft terms of settlement, and you insist that terms of settlement should be taken to the court for its possibility, and otherwise it will be drafted here, signed by the parties on the agreed terms between themselves, and it will be expected to be adopted as a mode of entertaining the issue arose. So that's all for this.
That was a very beautiful. Please, the next person. We are all the dates of here. The next person. Please, your parties are waiting. We are waiting.
Good morning, gentlemen and ladies. My name is Janet. Welcome you to today's meeting. Throughout the process, I will prefer to be known as Janet. And I want to thank you for choosing mediation as the process of settling your dispute. Thank you very much. I want to proceed to introduce yourselves and tell me what you prefer to be known as. And I want you to know that the goal of this meeting is to make sure that we make you voice your interest and help you to reach an amicable settlement. And before we go into it, I would like to know if you have signed a mediation agreement, and then if you have the authority to negotiate through to the end. Having known that, I believe by you signing this agreement, you understand what a mediation agreement is. And because of that, I'll just go ahead and briefly let you know what mediation is all about. It's a very, it's a process whereby it's voluntary. It's voluntary in the sense that you have chosen me to mediate for you, or if you feel at any point that you are not comfortable with that, you can withdraw. And while withdrawing, I will give you a little time to explain the reasons why you are withdrawing. As to the process, I want you to understand that it is a confidential process. We are bound by a double layer confidentiality, which means that whatever you relate to me in the process will not be voiced out to the public. It is going to be for only us, the parties here. And then the second part of this confidentiality is that if there's a need for us to have private sessions, we are going to have them, but I will not let out what the party tells me to the other party, except if I obtain permission. And then also part of the process is that I will be letting you voice out your interest. You will inform me about your interest while I take notes. But you know, being that it is confidential, at the end of the day, whatever notes I take today, we are going to shred them. And then when you are done telling me what it is you want me to know, I will recount it to you so that we are sure that I understood you very well. And then for those that are following us online in this mediation process, I want you to know that it is a private business. And for that, you shouldn't record. And then I want you to keep your speakers muted if you are not talking, and then keep your cameras on you and make sure you're the only ones in the room. And then to go further, I want you to understand that I'm here not as a judge or an attorney, but I'm just a mediator to make sure that the process is a success. I'm just going to guide you as to how you should do it. I'm not going to be a witness, neither am I going to give you legal advice. So bear that in mind. And then in my previous mediation sessions, I realized that participants have had us to set rules. I don't know if you would like to set rules for your own. I would advise that you set rules, for example, that one person should speak at a time, there should be no interruptions, there should be respect to other parties, and so on. So, you want to make rules? Thank you very much. And then I want you to proceed now to go into informing me about your requirement. Thank you.
These are very powerful. Good morning, everyone. I welcome all of you to this proceedings of today. My name is Amina Yahya. You can call me Amina. I am a trained mediator trained by Shati'S. I am here to settle your dispute. I welcome you all, and I pray that, and I thank you for choosing me as your mediator in this proceeding. I would like you to introduce yourself and tell me what you want me to address you as.
I also want to tell you that you own your process and proceedings. I am only to guide you in your process and proceedings, and I would like you to settle your dispute between yourselves. I'll only guide you in your dispute processes, and I'll also give each and every one of you 10 minutes to say what you want to say. But if you would like to talk to me outside the proceedings, so I would like you to indicate the interpreter.
Radio. Bluetooth mode.
If you have any personal issue to discuss with me without anybody knowing it's confidential, I will also listen to you to sit and talk carefully. But in the case where
Line in.
I would like you to explain when the need arises. And I would like to tell you that this all what we will discuss here will be confidential, and it's based on your choice. So you own your process and proceedings. And in the process where you are not satisfied with my proceedings, you can
Bluetooth mode.
for the proceedings. And I will also want
Line in.
you need to sign a dispute agreement. Well, a dispute agreement whenever you resolve your problem, and I will also reach a prayer that we will settle this dispute between you amicably, and all of you will be satisfied with the situation and position you take. I would like to also tell you that you own your process and proceedings. So I'm only to guide you on what you are doing. Thank you. You can now start with your proceedings.
Thank you very much for the beautiful and powerful opening statement.
Compliments of the day. Yael Shakdato, I'm a certified mediator, Settlement House, ADR Training Institute. Here in the mediation session, I would like you to introduce yourselves to parties. Feel free to discuss issues. We are not in the court session, so be free to express yourself. I would like to be addressed as Mr. Dato. For the sake of these proceedings, I want you to know that I am here as a neutral party in this mediation process. Just know also that it is meant to aid you to settle your differences amicably. Now, I want to also confirm that you've signed this mediation preliminary agreement, thus stating that you have voluntarily given your consent for this mediation session. And one very key important component of this mediation session is the voluntariness. Yes, it's not forced, it's voluntary, and it is confidential in that it's meant, whatever is being discussed here is meant to be kept privately, except the consent of both parties. That's source number thing. Now, I want you to know also that this mediation session is meant for particular sessions, depending on agreement of parties. It's not that we will start and then conclude necessarily. Can also reconvene, and we can also break into focus. It's not a court session as, and also I'm a neutral party here, in that I'm not meant to be an attorney or a judge to impose my opinion. You control the session yourself. I'm just here to guide and session properly. So just feel free. And also, the mediation session is binding on you, the parties. And if at a certain point you don't feel free with the proceedings, you can also withdraw. Also withdraw. It is permissive for you to withdraw. And you kindly state your reasons why you actually want to withdraw. And also, I want you to know that there are rules also guiding proceedings. For example, while a party is expressing his or her opinion or expressing himself, the other party should give listening ears and not interject or interrupt unnecessarily. When he finishes, the other party can also kind as well with his own points, opinion. Yeah, it's a friendly process. It's a friendly process. And I assure you that the outcome, you will be satisfied with the outcome. Be polite. When expressing yourself, be polite. It's not a fight. Politeness is very important, and it's not, don't be argumentative. Feel free, feel relaxed. I believe that at the end of it, you all go back home satisfied that got what you want. It's a win-win situation. We are not supposed, no party is supposed to go with the sense of loss. Every party is supposed to go satisfied. And at the end of it, all that has been resolved will be penned down in writing. The parties will go back with copies of whatever the agreement. And also know that depending on your decision, it's an agreement that you can actually register it as a consent judgment in courts. If you so wish, it's not mandated. It's not mandated. The mediation agreement is to end here. So I'm just presenting an alternative, or I'm just presenting an opinion too. That's, you parties, it's all depending on you. But knowing that I'm impartial, I'm supposed to be impartial. I'm not supposed to impose my decision on you. So feel free. It is less, saves time and costs. That's one very important aspect of it. So enjoining you to give your best, and at the end of it, you will refer others. And I'm sure that you'll be well satisfied. My name once more is Shati'S. I'm the mediator here. So I believe, and I believe that you will also someday join to be mediators. Thank you.
That was a powerful statement.
Good morning, all. My name is Adamu Abdullahi Lawat. Apart from being trained by Nigerian Law School, as to the Nigerian bar, as the solicitor barrister, the Supreme Court of Nigeria. I'm also well trained and certified by the Settlement House Area Training Institute as a mediator. So this is my introduction. So please, you can introduce yourself to this session. Okay, I've been introducing yourself to this session. I welcome you to this session. And this session, we call it mediation process, in other words, mediation. So mediation is voluntary. Therefore, you're free to make any offer and make any acceptance or accept any offer made by either of you. My role is just to assist you in the process, in the sense that I can assist you to arrive at a decision, but you are the one to take the decision and the process. Therefore, I will expect information from you. We call it facts, so that we can know how to control the session. But nevertheless, there are some rules of the session, some of which are, if one party is talking, the other party should remain silent, should keep quiet and allow him to finish before either making other offer or accepting the offer made by the other party. And all the information you gave here is treated as confidential information, so you're free to say anything. Nobody will use information in anywhere or litigation or whatsoever. It's a very confidential. And as I say, it's a voluntary process. What we can only take to somewhere is the issues or what you agreed upon. So it is the only thing that we can take the court for sign. But so in a nutshell, this is the opening statement. Thank you for choosing me as mediator. This is what I can do.
Sorry, Your Excellency. Your Excellency, we want to call the front.
I will come today because it's finally. My name is
Thank you very much.
My name is
Thank you very much.
Good morning, and welcome to today's session. I think he is Latifat Bello. I would like to be addressed as Latifat. I'm a trained mediator trained by the Shati'S in settlement with ADR Institute, and I will be your mediator for today's session. I would like you to introduce yourself and let me know by what you want me to address. Once again, I want to thank you for choosing this option as a process for resolving your disputes. By way of introduction, mediation is a voluntary agreement where you decide to bring your situation or matter for amicable settlement. It is a voluntary way of settling your dispute. So you actually control this session. My own is to guide you in resolving this amicable. So in the process of doing this, we have I will ask both of you to tell me what the issue is about, and where necessary, we will bring out for separate session where I can actually understand what the problem that is, if you choose to. I also want to add that in case you want to have online participants that you want to join this session,
we have advised them to mute their phone and there will be no recording. And I want to reassure you that these sessions are confidential and you have a cloud of double confidentiality. As at the end of this session, whatever notes I take will be shredded, and I will also not be forced to be a witness in any proceeding that may arise if this procedure does not align with your disputes. I can only be asked if compelled by the judge to so do. So in ordinary circumstances, I will not be asked to serve as a witness in case you decide to go into litigation. I further want to reassure you that you control this session, and then whatever you decide to do, my own is to guide you and ensuring that we resolve this amicably. Where this procedure does not align with your resolution and you decide to go further, I would ask you to give me 5 minutes of your time to explain why you chose not to settle according to the dictates of this mediation. Once again, thank you for choosing this option. And I reassure you that we ensure that we resolve this in the best way possible and to the best interest of both of you. Thank you.
A very beautiful statement. Say that's all. It's now time for us to discuss the weaknesses and strengths of everyone's opening statement. So I don't know who is ready to start.
I have to observe that. This was Samala. Well, we did well. We didn't spend the necessary time with the opening statement, friends, with the parties. What to state whether, ask them whether that complete or partial authority to do the mediation. Also forgot to state that, to explain to them that is the entire process was voluntary. We have also to state, to tell them, to inform them that if they are able to discover their various interests and be able to settle, that would be a very good help. Okay, you'll be very happy with that. But by and large, he was able to manage the opening statement very well. Mr. Douglas also tried, but he was so slow that it took a very long time.
Please, can I just interject? The first person you mentioned, let me also say something before you enter the next. I will just say it briefly. The first person you mentioned,
Mr. Samana.
yes, he emphasized well on confidentiality. He did well on that. And he did not talk about private office. I think that's one thing I want to no, the skip time. Let's wait for the person on time.
Awa, can you hear us?
Yes, I can hear you.
Okay. You are supposed to give your opening statement.
Okay. Can I go ahead now?
Can you on your camera, please?
Okay, you have to give me access to the camera. I've been trying to, and it's not, maybe I need access from you.
Try owning it now.
It's not working.
Okay, just go ahead. If we... Okay.
Okay. Good morning. My name is Barrister Hawaya Ayaseyuti. I am the mediator appointed to address your issues, to settle your disputes. This is an ADR, meaning alternative dispute resolution. So I will not be dictating over your issue.
Hold on a minute.
Hold on.
Okay.
Okay, speak, let's hear you. Speak, let's hear you.
Okay. So I'll be mediating over your matter. I'm a certified mediator trained by Shati'S ADR House. I'll give you the opportunity to vent out your issue, but please, you have to be precise and concise. And I'm not going to make decision for you. I'll give you the time and the room to resolve issues amicably. I want you to have at the back of your mind that mediation is usually win-win. It's not a win-lose, unlike litigation. So, and we pray and hope that by the end of this section today, we'll be able to conclude your matter. Hence, we'll have to adjourn it to another section. In mediation house, we have three sections. If at the end of these 3 sections we're unable to conclude our matter, on the 4th adjournment, you have to pay for the section.
On your camera now.
Okay. It's not working. It's not working. Can I continue? It's not working. Hello?
Can you try again?
Okay. It's not going through.
Okay, no, just log out and log in again.
Okay.
Yes.
Hello?
Can you on your camera now?
Okay. It's not still putting through.
Go ahead.
Should I start again? Should I
Yes.
start? Okay. Good morning. My name is Barrister Hawaii Ayaseyuti. I am a lawyer and a mediator. I'm sure we had your consent before I was appointed as a mediator to mediate over your matter by Shati'S Settlement House, ADR, Alternative Dispute Resolution. So I'll allow you to vent out your grievances, but please, you have to be concise and precise. And also, you don't have to be rude to yourselves. I will not be saying much in your matter. I will allow the two of you to suggest the possible ways of resolving your settlements. I'll just be your guardian in it. And I want to assure you that I will be unbiased, as I don't even know any of you. Or have any of you seen me before? So I'm going to be just to the parties, to the both parties. Also, in mediation, there's a confidentiality. That is, whatever we discuss here, we remain here, except by any way any of you takes it out, which I will advise that whatever we discuss here should remain here. If your phone's videos or audios recordings are on, I beg and plead with you to please put them off. So we have three sections of mediation. In mediation section, as in mediation, we have three free sections. That is, today the first one, we pray and hope we're able to resolve amicably. And if we're unable to resolve this amicably, we'll have to have another section. That's the second one. If at the end of the second day we're unable to resolve, we'll have to take an adjournment for the third day. And if after the third day we're unable to resolve, then we'll have to adjourn for the fourth day. And on the fourth adjournment, you have to pay because that is not free. So I plead and seek for your indulgence to cooperate with me and us to enable us resolve this amicably and easily and within a sufficient time, because that's one of the reasons of mediation. It saves time and it costs less. Thank you very much. I'm done.
Can you on your camera now?
I still can't on it.
Okay. All right. Thank you. So let's give feedback for online. Let's give feedback for online participants. Okay. And doctor too has not done. Doctor. You are not done your case. Okay. You need some time to let's continue. Yeah.
So now we are discussing the businesses.
Let us discuss the online part.
Okay, the online part.
For the last person that did the opening speech, was a wonderful one, except that in this process, you don't have to be too verbose. Sometimes, electorally, one has to just get into the wood and then give them the guide, and that's all. Prior to us, for those who are here with us, all the persons who did their opening speeches, they were all wonderful. everyone was good in his own way, insofar as they adhere to the prerequisites and then the pillars of opening speech. Except that I'm going to make a blanket observation. I will not report things anyways. Some of us, we are too extensive in their opening speeches. While there was one that kind of like dwell on the qualifications he has, instead of just dwelling on the process itself, which is mediation. I am a mediator, suffices. You shouldn't have gone into intimidating the parties with your credentials. Then there is one also that is trying to impress on the parties' limit of this and that. Insofar as we have observed, like I said, the pillars and then the prerequisite of mediation, which is voluntariness of the parties, the neutrality of the mediator himself, the time limit to giving the persons to address the mediator while stating their problems, and then the mediator being the guide to the process, and then there is utmost secrecy and all that. I see a very good opening speech. So I want to impress it upon all of us that we did very well. Thank you.
The next person I want to talk on weakness and strengths.
All right. Let me begin on a general note too. Like me, pick up some specifics. On a general note, I think we all did our best to try to recall the elements of the address and state them. Of course, some of us captured more of the elements than others. But on overall, I think we all did our best. Let me pick on some specifics, although without mentioning names. There's one of us, I think, exceeded the limit of the opening statement by getting into agenda setting and identification issues. I think from what we've learned so far, that is not supposed to be part of the opening statement. It is just meant to be introductory remarks and setting up some guidelines. And another person also, several of us omitted calling the parties at the end of the statement to make their own opening statement. I think that is the thing that marks the commencement of the proceeding properly. Because at the end of the mediator's opening statement, the parties are supposed to also make their own brief statement of the facts of the dispute. And okay, some of us again, at least one person, omitted asking the parties whether they have the authority to negotiate and settle the dispute. Like we learned an important element before the proceeding will begin and end, and at the end, somebody will say, I don't have the authority to make a final decision. So it's important to have that assurance or get that statement at the beginning. And, somebody also forgot to mention that the process is voluntary and that the parties have the option of leaving at any moment when they want to leave. And also, if they choose to do that, state the reason why they are leaving. I think it's important for parties to understand that they are not bound to remain in the mediation proceeding. They have the option of leaving if they want to leave. And one other person too omitted mentioning or stating or stating making emphasis on the role of the mediator, on what the mediator stands in the mediation process. Okay, there were emphasis on other aspects, but this particular aspect was not emphasized on. And another mediator also had less eye contact. Because I was trying to look at the face of each presenter. No, I didn't pay attention to others, but the particular person, there was less eye contact, which is part of what we learned. It's important that the parties will know that they are the ones being addressed. He has a way of making them feel noticed and attention being paid on them. And, okay, one other person too that spoke forgot to mention his qualification. Okay, while another person gave over qualification, another person forgot to mention his scope. After mentioning his name, he just proceeded to ask the parties to introduce themselves. So, I think that is important too, a way of establishing trust and credibility. Okay, I think that's my general summary. Thank you.
Anyone? Anyone? Okay. We all did beautifully well. Our opening statement very good. And based on the critics just said, they were right. Little things were omitted. But at the end of it, there is no hard and fast what the opening statement should look like. There is no formula, like start from here, okay, after opening, welcoming, introduction, start with confidentiality, or private purpose, or adjournment. Actually, there is no rule like that. Based on the mediator, we can just work on it the way it suits. Then we have to be very careful that all these elements should be summarized, but not simplistic. They should be very, very summarized. If not, we'll end up having an opening statement of more than 5 minutes. The reason why we give 5 minutes as the benchmark is any opening statement that is more than 5 minutes will definitely bore the parties. They'll be tired. They are eager to let you know their problem. So you trying to eat their time to talk about your qualification or every other thing. See, they'll be so impatient and anxious. So I just have little elements here that I will just read out. We have the welcoming, which all of us did well. And I even appreciate another person that even changed the style. I think he said something like compliment of the day. He changed the style as in me, I'm a unique mediator. Let me do my own, I think. Then we have the introduction, we all did well. And I think we have to be very careful with that introduction. Very, very careful. If not, it will make us talk too much. We know we have powerful series, but we just have to pick the vital parts that will help as a mediator. So pick what will help as a mediator so that they will know that they are the right person to mediate their matter and not that you're giving them citation. Then we have building credibility. We all did well, all of us. We did well in building credibility. Establishing stakeholder, that's the authority. Most people here to establish the fact that not everybody have full authority when they come to education people. So you have to establish that fact to know if the parties there have full authority. Explain the nature and scope of mediation. That's another place that one has to be very careful. If not, you will talk too much. The scope and nature of mediation. Just make sure you just get the most important parts and summarize them in a very simple way. You know, mediation is a simple process. Not that you will look for buzzwords to impress them. They are just there to get solution to their problem if possible, or just to air their grievances. So be very simple, so that they will be able to appreciate the process. We have explaining the mediator's role, and all of us did well. Most of us stated that we are in charge of the procedure, not the decision making. Decision making is in the parties' hands. So we did well. Then disclosing note-taking purpose. A lot of us get right. We disclose the fact that taking note, but at the end of it, we shredded. So we did well on that. Then establishing ground rules. I also enjoyed the fact that some of us really went as far as making the parties comfortable by telling them that you can set your rules, set it. So, and that's a very good one. You make them more relaxed, and that part really make them feel in charge, since they are the ones setting the ground rules. And once they set the ground rules, they will not default because they are the creators of the rules. So then, discovering, then in a condition where parties maybe they don't even know what to set, then you can hide them. Then discovering time constraint. Okay, like the time constraint, some parties want to talk from now to tomorrow. If you don't guide the narrative, you will get tired, and all of you will get tired. So sometimes when you observe, because before the mediation you have the fact, it's mediator, you've gone through the facts already. So you'll be guiding them so that at the end of it, people will not go around the cycle. The issues, and that's where agenda setting is very important. Issues that you distill and you confirm that's the main issue that the parties have dealt with, not going around the cycle and based on unnecessary things that will end up wasting the time of parties and the mediator. Then explaining, okay, this particular part is okay, there are some experts mediation. I don't know how to put it clearly. They call it explaining the role of outside experts. There are some times when, if you want to mediate, maybe in a family issue, maybe one of the parties will say, okay, I want to come along with my mother or my parents. I want to come along with my pastor, my imam. I want to come along with. So if they mention the fact that they want to come along with experts, then those should also be included. And also, we have securing the commitment to begin. All of us did well to that. We all ascertained that they agreed to meditate. Then transitioning to storytelling. Yes, I know some of us default in that. We did not really, you have to transition properly so that the parties know that, okay, this is my own turn to speak. And I also appreciate the fact that some of us emphasize on the fact that, okay, the complainant should begin, complainant should commence, because the complainant brought the matter before you. He has to tell his story so that the respondent will be able to know what to say. Because you want to start with the respondent, will say, I don't know what to say. I don't even know why you brought me here. So some respondent can go as far as frustrating you. And if you wake up at the wrong side of the bed that day, you will indeed be frustrated. So it's good to start with the complaint. So, and many other parts that will be all, the elements are many, but you have to pick the elements that are relevant to the issue. Family issue, you know that you will not be able to private proposal. There are issues that will come before you will not need proposal. So it depends on the issue. But it's good for you to let them know in a summarized way, elements through your open statement. So thank you very much. I don't know if Mr. Nanchan has something to add.
Did everybody make did they do the criticism?
Some persons.
Okay, not everybody had. The idea was, your worship, agreed on your own. Are you ready? Okay. Okay. So the idea is to allow some of you make these observations by yourselves. When you are able to identify that this is the procedure that needs to be followed, and eventually it is followed, then that's a part to understand. It shows that you understood and were able to point whether someone is doing fine or not. So now, is there any question on this opening statement? Doctor has done. But is there anybody that has not done this opening statement aside from emotion? No, nobody. Huh? Is there nobody? Is everybody has done? Huh? Hmm? No, everyone has done his opening statements. Okay, that's good. So now we will go into the timetable. What do we have on the timetable? Huh? Okay, practicals. So now you now have enough time to do your practicals. Madam, come on, continue your time. Okay, so let's go into the okay, I can see Mr. Samuel. Okay, I will reach out to you. Let me just give me a minute. Let me find out. So, we're supposed to go for practical simulation now, but okay, okay. Okay, fine. Okay. We were supposed to go for the practical simulation, but what we'll do is we will take one of the class. So we're supposed to have practical simulation before starting a mediation practice, then charging for ADR. Charging for ADR services. So as you know, we have been looking at different aspects of ADR and the things that we need to do. Now, we are going to take one of the classes where the facilitator wants to exchange the time so that we will now shift our simulation. After the class, we can take the simulation before I take the last class. So, you know, having learned, and I'm very impressed, to say the least, very impressed. Your worship, you have to do your own. We are waiting for you, right? You have to do, and it will be good to do it before we go into this session. Just relax, do what you can, right? Is that correct? Are you ready? So, in 5 minutes time, let us have, maybe less than that, let's have your worship do our opening statement before we commence.
Everyone, good morning and welcome to this mediation session. My name is Agatha Bumi. I'm certified mediator trained in Shati'S, and I want to thank you for choosing to settle your mediation. I'm kindly and to put your
Yes. Put the camera. Put the camera to put the microphone to your hand.
Okay. Hello, everyone. Welcome to this mediation session. My name is Agatha Muni, and I am your mediator. You can address me hereafter as mediator. I want to appreciate you for choosing to settle your dispute through mediation. And kindly introduce yourselves. Before we begin, I would like to bring to your attention the fact that whatever you say here is guarded by confidentiality. It means that everything you say is protected, and even I, as your mediator, cannot be ordered to give evidence as a witness as to whatever you have stated here. And whatever notes we have taken will be irredeemably destroyed at the end of the session. We shall be having 3 sessions. The first session will be 10-minute session, a joint session. The second session will be an individual session, one-on-one session of 5 minutes per person, while the third session will be 10-minute session. If we are unable to conclude after the third session, and there's a possibility of still proceeding, we shall adjourn mediation session to another convenient date. Before we commence, I would also like to state that in my previous mediation sessions, parties have set the ground, they have been allowed to set the groundwork as to the way and manner the mediation session goes on. Would you like to set your own rules? If you do, speak. I think I've exhausted everything I have in my head.
All right. So
Okay, so Mr. Samuel. Mr. Samuel, are you ready?
Good afternoon, Mr. Natchan. Please confirm if you can hear me.
Yes, we can hear you. So some of you are already conversant with Mr. Samuel. Mr. Samuel is someone very, very interesting to listen to. He is one of our facilitators. He has always been available to help us sort out a lot of complex issues when it has to do with mediation. Very, very passionate, and is a mediator, an arbitrator, a negotiator. He's an ADR registrar. He is a lot of, he just like me, he actually practices in almost every area of ADR. And aside from that, he has some additional qualification coming from his background, which makes him an expert in his field. He's going to, he currently works with Edo State multi-door courthouse. And I believe that he is he has a lot of things to share with us. You know, first he is a pastor, and he is a peace ambassador. He's a distinguished ADR practitioner to the core. He possesses advanced knowledge and understanding in peace and conflict advocacy, community mediation, family mediation, workplace conflict management and resolution, peace building, among others. He is, you know, while we're reading this profile, it's so that when you have issues or disputes, you can reach out to Settlement House. We have panel of neutrals that are experts in different fields, and they can be appointed, or we'll send them to you. You check the website and see their profile and see the one that suits, that has the subject matter expertise. Are we together to help navigate your dispute? You know, he is a minister of God. He has a PhD in theology from the Redeemed Christian Bible College and a graduate of the Word of Faith Bible Institute. He, in the Living Faith Church, he's a lover of peace and the youth, as you can see when he talks. He has passion for advancing the gospel of ADR, which accounted for his willingness to volunteer and facilitate various means of peaceful and amicable dispute resolution. He is the principal consultant of Paxi Juris and Associate Consult and the founder of Rehoboth Encounter Prayer Group. He is a certified peace and security consultant. Please listen carefully. He is a certified peace and security consultant, a chartered human resource consultant. He is a fellow of the Institute of Chartered Mediators and Conciliators. He is a member and a resolution specialist of the Institute of Chartered Mediators and Conciliators. That's the ODR panel of neutrals, online dispute resolution panel of neutrals. He is a member of the Nigerian Institute of Chartered Arbitrators. He is a faculty member of Settlement House ADR Training Institute, Shati. He is also a faculty member of the Nigerian Institute of Chartered Arbitrators. He is a fellow of Chartered Institute of Human Resource Management. He is a fellow of the Institute of Global Peace and Conflict Management, and he is a member of the Society for Peace Studies and Practice. He is the current member of the Association of Multi-Door Court Practitioners and the Edo State Multi-Door Courthouse. He has experience that cut across diverse areas of endeavors, as he has consulted for the Nigerian Youth Service Corps, NYC, and UNICEF as a master trainer in the National Adolescent Reproductive Health, HIV and AIDS projects through the NYC, and where he carried out several capacity-based interventions in various NYC camps. He has also consulted with GIZ and strengthened the system on strengthening the system of dispute resolution in the marketplace. He has attended several trainings and hosted several seminars and has modern technology as his toolkit with proficiency in computer usage. When you see his slides, sometimes you see his abilities displayed. He has passion, a great one, for capacity building and research, and he's married to a beautiful wife and blessed with children. Please join me. Welcome, Mr. Samuel Osai Arabasai.
Mr. Natchan, good afternoon. Good afternoon, my lords. Good afternoon, your worships, your honors. Good afternoon, highly esteemed participants, virtual and physical. I am just your brother from another mother, and it is a delight to find my way into your midst today. I never thought it would be possible joining you, but I had to sneak out from an event to make sure that I join you on this final lap of our training. And I do hope that in the next couple of minutes, I will be better informed because I'm having the rare opportunity to interact with great minds. Thank you so much. Thank you for Shati. So I want to quickly begin sharing my screen. Please, if you don't mind, confirm if you can hear me and if you
Clear, sir.
You can see my screen, please.
Very well, sir.
Thank you so much. Thank you so much. Okay. Now, in the next couple of minutes, we want to quickly consider the topic charging for ADR services. Charging for ADR, properly known as alternative dispute resolutions. Others call it African dispute resolution. Others call it appropriate dispute resolutions. And some call it alarming drop in revenue. We want to see how we can charge for ADR services. We'll quickly go through the topic of today by beginning with our opening quotes. Reference pay full price. You will agree with me that this is true. If you are my friend, you are a lover of my progress, you will actually pay in full for goods and services that I render. Because as is popularly said, business thrives when friends and family pay. What do they pay? When they pay for goods they receive and for services being rendered, business will thrive. In other words, when friends and families do not make payment for the goods they receive from you, for the services they enjoy from you, the longevity of your business may be short-lived. Now, quickly, if you look at the screen to your top left, you see a device. I may not be able to take feedback from participants, but I would have loved to have an interactive section. To my top left, there's a device. Mr. Nachang, is it possible I hear from the participants? Is it convenient? Okay, let's just continue. To my top, okay. Is it possible I maybe ask 1 or 2 questions and get a response from the audience? Is it possible?
Yes, sir.
Thank you. To my top left, there's a picture. Can someone please tell me what you can see on that picture to my top left?
Yes, phones and charger.
Okay, phones and charger. All right. Okay. Yes, thank you. We have phones, we have a charging cord, and we have a power bank. Without the power bank and without the charging cord, what we enjoy from having the phone at our disposal may be limited. Once the phone runs down, you are cut off from enjoying the applications in your phone because it is not charged. And at that juncture, what you need is to charge it. What happens when we do not charge our devices? Can I get a response?
The phone will run down.
Okay, your device will run down. Okay. Now let me ask that same question in another form. What happens when we do not charge our devices properly?
Will have no currency of power battery.
Thank you so much. So if the device have the capacity, yes, someone is talking, please.
Yes, it will stop midway.
Thank you so much, Howard. Thank you. I want to appreciate all your responses. So if you do not charge your device, you will not have access to enjoy the services. You'll be cut off from networking with others. But when you charge and you do not charge properly, you discover that if you had a time frame, the device was supposed to last for 4 hours, it will not last up to that extent. So there's the need as trained mediators to know how we should charge for our services as ADR practitioners, and a step beyond that, not just charging, we should know how to charge properly. Please permit me to borrow this from the medical balance. Drug abuse. We are being told that drug abuse is the excess intake of drugs without therapeutic prescription, either excess or less than the quantity you were supposed to take. So when we do not charge for our services or we do not charge properly, there's a concern. So within the next few minutes, we want to see how we can charge and how we can charge properly for the services we render as ADR practitioners. A fee is a fixed price charged for a specific service. In other words, a fee is tied to a service. Fees are applied in a variety of ways, such as costs, charges, commissions, or penalties. A fee may be a result of a cost of a service rendered, cost of goods bought, or charges when you want to make withdrawals through a POS machine. You make payments if you are withdrawing 100,000 naira, you collect the 100,000 naira, exchange it through transfer, and you make charges, extra costs on that services you've gotten from that particular agent, commissions or penalties. Fees and charges means all fees and charges authorized to be received by the specific authority. So beyond the fact that a fee is a charge for a specific service, beyond the fact that we have different classes or categories of fees, it is important to understand that fees are regulated. Fees are regulated as far as ADR is concerned. Fees are regulated. It's not just arbitrary. There's a range within which we can charge. Now, how do we explain service charge to a client? We've seen sessions whereby somebody will ask, we are the ones that have dispute. Must we pay you to settle our dispute? You guys are taking advantage of us. And the question we usually ask, if you knew what to do, you will not be here this moment. If you had a way around this issue, you will not be here this moment. Service charges allow businesses to continue providing excellent customer support and products. If service charges are used to improve the quality of product or services, customers will be more likely to return. What are we saying? The essence of charging of fees as an ADR practitioner is not just to live large and enrich yourself and meet your basic needs. We should understand that the revenue we derive from being an ADR practitioner is to enable us improve ourselves, is to enable us improve our capacity, is to enable us train and retrain ourselves. A business, we are being told, is different from the owner of the business. So as an ADR practitioner, beyond getting revenue or remuneration from fees, we should understand that there must be need for us to update ourselves and upgrade ourselves. Taking a case study from the CEO of Shati'S, he's always improving himself, back to back, trainings upon trainings. So where he is today and what he is today is a reflection of the years of training he has put into himself. And I'm sure before April next year, you will hear a series of other accomplishments he has been blessed with. Coming on board this training, it is the beginning of an endless process. So the fees we charge as A0 practitioners is not just to satisfy our personal gratifications, but enable us to render more services. Mediation is a vital service that adds enormous value to the lives and businesses of people. Permit me to say this, mediation is a profession. We have engineers, we have medical practitioners, we have accountants, we have lawyers. Mediation is a profession. It is a calling, and mediators deserve decent compensation. Pro bono services is good, but not in all cases. As an accountant, you go to your office, you dispense your duties as an accountant. When you return home, you become your normal self. A medical doctor goes to the hospital, puts on his attire, and does what he needs to do. When he comes back home, he takes off the cloak of the medical profession and becomes a normal human being. An engineer puts us in safety helmet, safety boots, puts on his jacket to carry out what he needs to do. And when he's done, he returns back to being his own self person. But a mediator puts on the skin of his profession and never takes it off. In other words, as a mediator, you are on duty 24/7. The training we have been exposed to for the past days has not only given us skills, it has become a cloak that we must put on. Either as a lawyer, either as an engineer, an accountant, whatever our qualifications are, whatever our professions are, it can be subsumed under mediation. And as a mediator, you must understand that there's need for us to get value for the services we render. Permit me to take this few time to share a short story with you. A man's car broke down on the highway while he was traveling. And he resorted to all different roadside mechanics to help him fix his car. But all the mechanics, when they come, they discover that they are unable to fix it. He pays them money, but they are unable to do well to bring the car back on the road. And after 2 hours, they referred him to someone that was in a very far distance. He got the person, and when the man came, less than 5 minutes, the man fixed the car, and the car came back to life. Because he was desperate, they did not bargain before the man started the job. And when he was done, the man said to him, "This is my fee." And the owner of the car exclaimed, "How can I pay so much for what you did in less than 5 minutes?" And the workman said to him, "You are not paying for the time I spent in helping you fix your car. You are only paying for the years I used in gaining the experience that enabled me not to waste your time beating around the bush." What do we gain from this story? If I have the opportunity to get feedbacks from everyone, I know I'm going to get different response from everyone listening. How do we relate this to mediation practice? It simply means the more years of our practicing mediation, the more the tendency of our fee scale will be high. You don't expect someone that is coming into mediation today to begin to earn fees as much as someone that has been in the profession for 5, 10, 15, 20 years. It is not possible. So as we grow in the profession, as we invest in ourselves, as we give way to training and retraining, it becomes very, very practical for our scale of fees to increase. You can't compare a consultant medical personnel to get the same fee as just a fresh graduate from medical school. The type of dispute that usually comes to mediation is of different types. We have monetary claims. The dispute may revolve around monetary issues, contracts, agreements, whatever it is. If it is based on monetary scale, there are different fees that may be charged. And these fees are usually a reflection of the money in question. There's the filing fee, there's the process fee. We have the small claims, we have the medium claims, we have the large claims, and we have the complex claims. Small claims refers to, it actually depends, this is just a hypothetical diagram. It actually depends on the practice direction of the dispute resolution center. Every multi-door courthouse, every dispute resolution center has a scale, and in that scale, they will tell you any dispute between 0 to 500,000 naira. This is the fee we are going to charge the parties. Any dispute between 500,000 naira to 1 million, this is the fee we are going to charge the parties. Any dispute between 1 million and 2 million, this will be the fee we'll charge the parties. In other words, the percentage parties, the fee parties are asked to pay is a percentage of the claims that makes up the dispute. So we don't just charge arbitrarily. You charge as a percentage of what is at stake. If you are an independent practitioner, you can come up with your own scale of fees, schedule of fees that will reflect 5% of the amount in dispute, 10% of the amount in dispute, 20% of the amount in dispute. All these will enable you to know what to charge your client. And permit me to state here, in a dispute resolution center or in a multi-door courthouse, there are different classes of fees. When parties come in with disputes, it's usually documented. The dispute must be documented. These are the issues that I have. this is the person I have the issue with, and these are my demands, these are my interests. We usually call it statement of issues. The first person that reports a dispute in mediation is called a claimant. The person is reporting is called a respondent. So the claimant comes in with a summarized document, not as bulky as the brief they file in litigation. A summarized document telling us a brief background of the dispute and what they intend to gain at the end of the day. They need to make payment for that particular filing. It's called filing fee. In some other centers, they have what they call process fee. They make payment for the process fee, processing the document, because that document must be served to the other party. In most cases, the other party may not be aware that the claimant has come to make claims at the multi-door court. So the claimant pays for filing and also pays for process to enable the multi-door courthouse serve the other party the documents that have been filed. The respondent also makes his own copy responding to the claims in the statement of issues, submits it, and make payment for filing. So we have filing fee, we have process fee. When all the documentation has been exchanged, it now becomes time to invite the parties for mediation proper. There may be preliminary hearings, there may be pre-session. At that stage, the parties are now told what to pay the center to enable the center accommodate them for the process of the dispute resolution, and what they are to pay the mediator for the process they are about to go through. So charging in ADR is of different classes. We have the filing fee, we have the process fee, we have the session fee, and the mediator's fee. It all depends on the structure of the multi-door court or the structure of the dispute resolution center. An ADR practitioner as an individual can set up a center. So based on what you agree, you subject the parties to. In multi-door courthouses, we have panel of neutrals. Panel of neutrals are not necessarily employees of the multi-door court, but they are a pool of ADR professionals. When parties come to the multi-door court and lay claims, looking at the nature of claims, the center cannot look at who among our pool of neutrals can handle these issues. They cannot assign somebody from the panel of neutrals to handle the issues or make recommendations to the party to enable the party choose who they feel will handle the issues for them. Remember, I said filing fee to enable them receive the documents, process fee to enable the center process the documentation, session fee. Session fee goes to the center because while mediation is going on, the center may provide water, may provide biscuits, may provide sweet, may provide soft drink, whatever the case is. They charge parties for this. Then they also charge the parties the mediator's fee. There's an amount to be paid the mediator for rendering his services throughout the mediation period. Please let me confirm these stages I just mentioned. I hope we had them clearly. Are we okay? Are we still together, please? Are we still together, please?
Yes, we are, sir.
Thank you so much. Can I continue?
Yes, you can go ahead.
Thank you so much. I appreciate you, ma'am. Now, having said that, we also have non-monetary claims. These are claims that does not have a specific amount in dispute. We have simple claims, we have complex claims, and we have compound complex claims. In other words, the multi-door court or the ADR center uses their discretion to fix a fee on the dispute. Remember, we talked about the monetary claim. Is usually a percentage of the amount in dispute based on the range. But in non-monetary claims, what is the issue? How complex is it? If the more complex the matter is, the more the fee that will be charged the parties. And permit me to say this, the profile of the mediator also has an input in the fee that will be charged the parties. In some multi-court houses, regardless of the profile of the mediator, there's a flat rate that they charge parties. But in some multi-court houses, the profile and the experience of the mediator influences the fee that will be charged the parties. So the more experienced you are, the more years you have spent as an ADR practitioner looking at your profile, the multi-court will know what to charge the parties. There are usually some government matters, some high-profile matters that come to the multi-court houses or come to private dispute resolution centers. Looking at the personalities involved, the multi-court center or the dispute resolution center, please, the multi-court house is usually a court-connected ADR center. And I'm glad that in Kaduna Valley we have a functioning multi-court house. And I want to use this medium to appreciate the director, the new director that has been appointed, wishing you a successful tenure. And we know there are better things that will come. When we make reference to dispute resolution centers, these are personal and private ADR centers that are set up by ADR practitioners, just like the way you have chambers, law chambers being set up by lawyers. So in some ADR centers, there's a flat rate per dispute, but in others, the profile, if we have high profile matters, the center looks for high profile ADR experts that will help them handle the issues. And bringing in those people, the fee they charge may be high. Summarily, we have monetary fee and non-monetary claims. Monetary claims, you charge the parties per percentage of the amount in dispute. Non-monetary claims, the complexity of the dispute determines what will be charged the parties. Amongst what will be charged the parties, we have the filing fee, which goes to the center, the process fee, which goes to the center for the purpose of documentation, the session fee, which goes to the center to enable the center to make provision for little refreshment, like payment for venue, then the mediator's fee, which goes to the mediator. Permit me to add, in practice, some multi-court houses, they pay the mediator a percentage of what was paid. Let me explain. If the center charges 2,000 naira for filing fee, that 2,000 goes to the center. If it charges 5,000 for process fee to enable the center file the process to the other party, that 5,000 goes to the center. If the center charges 20,000 naira as session fee to enable the center provide refreshment, provide other logistics during the session, that 20,000 goes to the center. Now, if the center now charges the parties like 200,000 naira for the disputes, some ADR centers will pay that 200,000 lump sum to the mediator. Some other centers may pay the mediator 50% of that money and retain the other 50%. It all depends on the practice direction and the law setting up the ADR center. But the good news is this, the mediator always goes home with a fee. In some cases, before the matter begins, the parties must have made payment for all the fees. In all cases, they make payment for all the fees. All the fees are usually paid before the session commences in earnest. When the session commences in some ADR centers, the mediator is paid his fee immediately he begins sitting. In some other cases, the mediator is only paid his fee when the process has ended. And in paying the mediator, the center takes some things into consideration. The mediator that has been assigned this matter, is he within jurisdiction? Does he live in Kaduna? If he lives in Kaduna, fine. The amount we are going to pay him, there's a professional fee, there's his administrative fee. What if the mediator does not reside in Kaduna? He stays in Abuja or Lagos or Port Harcourt or Delta. Because of the peculiarity of the matter, he has been the one choosing to resolve that issue. The extra fees he's going to expend must be taken into consideration to enable him not to run at a shortage. His flights, hotel accommodation, his meals, all those will be encapsulated in giving the parties the fee they ought to pay. I hope we are communicating. In some jurisdictions, the fee that is being charged, I'm talking about the session fee now and the mediation fee. In some jurisdictions, it is a fixed rate. Even if the session takes about 2 months, 3 months, 5 sittings, 6 sittings, 8 sittings, there's a fixed rate. In other jurisdictions, it is per hour. Parties pay per hour. Usually in the Western world, this is what is obtainable. 1 hour, there's a fixed rate for 1 hour. If the mediator sits with you for 1 hour, there's a fixed rate you are supposed to pay. If it exceeds 1 hour, going to 2 hours, there's a fixed rate you are supposed to pay. So they will continue to sit until the process ends. If the process takes 20 hours, your fee is per 20, multiplied by 20. In some jurisdictions, it's per day. Even if you spend 8 hours per day, there's a fixed rate. So it depends on what is obtainable in your jurisdiction. Right, let's just happen this. A dispute resolution specialist is a person who is trained and as such has acquired the necessary skills in exploring various either mechanisms, especially mediation, in helping parties resolve their disputes, conflicts in a way and manner that is acceptable to both parties. This definition is within the confines of mediation. The role of a dispute resolution specialist includes investigate and gather all relevant information to the claim brought before him. You may not just streamline yourselves by looking at the documents before you. You may not just streamline to listen to what the parties have to say. You may need to think outside the box. That's what they call ZOPA, Z-O-P-A, Zone of Possible Agreement. A dispute resolution specialist, a mediator needs to be emotionally intelligent enough to go to think outside the box in seeing how he or she can bring parties to a mutual agreement. Charging in ADR services, your charges as a dispute resolution specialist depend on whether you are an employee in an organization. If you are a staff of a multi-door court in some jurisdiction, even if you resolve a matter and parties make payment, you may not be paid because you are an employee of the organization. Your monthly allowance is what comes to you. In some other dispute resolution centers, if you are an employee of the organization and you resolve a matter, they may decide to give you a little percentage of the money being paid by the parties. As a mediator, you can be an independent practitioner. You can apply and become a member of a multi-door courthouse panel of neutral. You can set up your own personal dispute resolution center. It simply means whatever the parties pay comes straight to you because it is outside the framework of an institute or organization. So when you are an employee of a multi-door courthouse, you are an employee of a dispute resolution center, it means that your mediation is being carried out in an institutionalized manner. While if you're an independent, a freelance, you are practicing mediation in an ad hoc manner. So basically, we have institutionalized mediation, and this is where you are an employee. Your salary may or may not cover the services you render. You have your monthly salary and maybe some allowances or bonus. I heard of a colleague of mine in her center. She resolved a dispute of over ₦1 million, and she was paid less than 100,000 naira because that is what obtains where she is, simply because she was operating within the framework of an institution. If you are in an institution, there are agreements, the practice direction, the civil court procedure rules that governs what obtains here is binding on you. But if you're an ad hoc, on the other hand, you charge your clients based on your skills, your experience, and whatsoever you charge comes straight to you and to your center, as it were. Categories of fee, we have the mediation fee, like we said earlier, the fees that is being paid for the purpose of mediation to cover all the expenses the center is going to run. We have the professional fee, the fee that goes to the mediator as its own professional fee. Now, dynamics of cost analysis. So an average market person, they'll tell you, I need my cost price, the cost price, cost for transportation, the profit I'm expecting, and any other miscellaneous cost. When I add it together, the outcome will be my selling price. Mediation or mediators do not run at a loss. In beginning your mediation career, you may not be too conversant in understanding the dynamics of charging, but as you begin to progress, you will understand fully the dynamics of charging for ADRO services. Don't forget that you are not just going to begin on your own. The journey begins from being a mentee, looking for established and renowned arbitrators or mediators or ADRO practitioners that you can learn from, because there's always what we need to learn outside the framework of a classroom. As a professional, if my services is needed to assist parties resolve a dispute and I need to be there physically, I'm not supposed to pay for the cost of my transportation. I'm not supposed to pay for my hotel fees. I'm not so those things are incorporated into administrative charges. Then my professional fee for sitting with you is clearly spelled out. All these fees are usually paid upfront before the process begins. I hope we are together. Now, permit me to use a few minutes to talk on understanding your why. Why are you doing what you are doing? It is sad to say this. Many persons are being trained as mediators, but they have not been able to understand why they are undergoing their training. So we're just drafted into the training, so we're co-opted. Oh, let me just go with you. Someone has said, I heard that my sister wants to undergo a training. Let me just go with her so that we can be there together. The question you must understand, I am here now. I don't know how we got into this training, but the most beautiful thing is we are here, having spent 4 to 5 days. Look at the resources we've put in. We must ask ourselves, why am I undergoing this training organized by Shati? Why do I want to become an ADR practitioner? What is my driving force? Why am I here? It is your why that determines your mindset and approach. You may be a wonderful and skillful dispute resolution specialist. You may be a wonderful and skillful ADR practitioner. But if you don't know your why, you may not be able to measure your impact and your success. So we must get this clear. Many persons, once they have completed their training, in the next 2 months, where is your certificate? They are looking for it. They just go back to where they've been. But I'm so certain that at the completion of this training, we'll be able to design and conclude what we actually want to make out of our lives with this new feather that has been added to our feather by the Shati'S. You have the skill to sing, good. But knowing why you are singing will help you to sing with a sense of purpose, and it will help you to identify your target audience. If your why is to make money or help people, or you just want to get knowledge, they are both do have a different approach. If your why is to make money, you have your approach. If your why is to help people, you have your approach. If your why, I want to become a mediator just for the sake of knowledge, you have your approach. So your why determines how far you will go. It's been said, if purpose is not known, abuse is inevitable. Factors to consider in charging for ADR. Ask yourself, is it institutional? If it is institutional, if it is a multi-document house, if it is a dispute resolution center, it therefore means it is the center that will charge the parties, because the center is already established scale of fees that you are not permitted to walk outside. So you must be in consonance, in conformity with what is on board. But if it is ad hoc, it is a bit flexible. That means the ADR practitioner, the mediator, can charge the parties directly based on his own appropriate discretion and discretion, conclude on the venue, conclude on other costs. It can be amended. Other factors we must consider, you must ask yourself, how important is this dispute to the client? You want to know the variables to enable you to charge the parties. How important is this dispute? What time and effort do I need to resolve this dispute? Is it something I can resolve in 1 hour, in 2 hours? It may your answer at this stage may not be too accurate, but it can help you forecast in order to do the needful. The novelty and difficulty of the matter, all these factors will enable you to know what you can charge if you are operating in an ad hoc setting. You will also ask, will there be a need for a special skill or service in the process? There are some matters that we handle. We may get to a point, one of the parties may need to undergo a DNA. And it simply means there's a special skill that will be needed for that purpose. Now, if you can forecast with your mediative mind, and I think this matter may likely proceed to a stage where we may get the skill of an expert. Maybe an accounting expert, a chartered accountant to help us look at the figures, or a quantity surveyor to help us check if it's a construction-related dispute, to help us evaluate to confirm the level of resources and money that has been invested into a particular project. In some rare cases, it may be for the purpose of documentation. Mr. ABC may say, I did not send that document. Mrs. XYZ will say, this is your signature, you signed it. So it becomes a question of authentication of signature. And that means we need a forensic expert to help us in that. So if the case has some flavor that we need the skill of professionals outside the mediation table. Don't forget, it is the parties that will pay for that service. It means that that fee will be incorporated into their fees. So the charges is a combination of different variables subject to the nature of the dispute. Usually, the total fee is split into two. The claimant pays 50% and the respondent pays 50%. But in some cases, if parties decide, the ratio of payment may fluctuate. We've done matters where one party decides to take responsibility for all the fees. And we've also done some matters. It is obvious that the parties cannot pay. We do it pro bono, free services. You just render to them your contribution to humanity. But that doesn't mean all matters must be done pro bono. While you charge for some matters, there are some matters you are likely to do pro bono based on the social standing and social class of the parties involved. The cost, value, or the importance of the subject matter, the result you obtain, all these are crucial in fixing the price for the process. The fee must be reasonable and commensurate with the service you render. Permit me to state this. If, as a mediator, I had initially cost that I need to make 4 trips for the purpose of the mediation section, and along the line, I have received payment upfront for my 4 trips, for my hotel reservations, and for other logistics, aside my mediation professional fee. Let me explain. Your professional fee, you charge them based on your competence. Now, all the other expenses you're likely going to make is part of the administration fee. It is stated. When the matter has been resolved, and at the end of the day, instead of 4 trips, I made only 3 trips. It means there's an outstanding of 1 trip. The fee assigned for that 1 trip must be returned to the parties. Let me state again, mediation is beautiful and transparent. I have a matter and I need to make trips. I tell the parties my professional fee is 500,000 naira. My professional fee is 1 million naira. That's my professional fee for this dispute. And I'll be making 4 trips. And each trip, my flight, including my hotel reservations and the logistics for moving around, each of them will cost me 300,000 naira. And I need to make 4 trips. That is 1.2. And I'm charging maybe 1 million naira as my professional fee. So the fee for that process as an ad hoc mediator is 2.2 million naira. One party is to pay 1.1, the other party pays 1.1. Fine, we are good to go. We are on course. And at the end of the day, I only made 3 trips. Maybe the 4th trip, I just used online. I didn't make any journey. When we do settle at the end of the process, court demands that the estimate for that 4th trip that I didn't make must be returned to the parties. But my professional fee as a mediator is sacrosanct. Please let me confirm, is my explanation clear enough?
Yes, sir.
Yes, sir. Yes, sir. Yes, sir.
Thank you so much. I'm sure after our training, Shati'S House, Settlement House, there's what they call Settlement R. There's what we call Settlement R, our continuous professional development courses, where each of these topics will be taken one after the other to enable you familiarize yourself with them more and more in details. Having said all that, I'm glad to make us understand that as a mediator, the prospects are wide. A mediator can function as a negotiator. You can help parties resolve issues as a negotiator, and you get your fee. You can help parties resolve dispute as a mediator, taking them through the process of mediation, and you get your fees as a mediator. Mediation is usually much more longer than negotiation. Most times, you may include negotiation in mediation. They are intertwined. As a mediator, you can advance to become a mediation advocate and earn your fees as a mediation advocate. Who is a mediation advocate? Don't forget, a mediator assists both parties. Is a third party neutral that assists the parties in resolving their disputes, putting them at the forefront. But a mediation advocate is like a private attorney to a party. When parties have cases in court, they go with their counsels. In mediation, it is a mediation advocate that plays the role of a counsel. Let me emphasize this again. For the purpose of litigation, counsels, lawyers accompany their clients to the courts and speaks for them and represents them in court. But for the purpose of mediation, we have a class of mediators that are known as mediation advocates. For the purpose of mediation, it is mediation advocates that accompanies parties to the mediation room. Their job is to prepare the parties and assist the process for a smooth resolution. And they get their fees as a mediation advocate. Accompany parties for the purpose of mediation, sit with them, tell the parties what to say, encourage them on how to navigate the issues, prepare their mind. You know, it's not a win-win, it's not a winner takes all. It's a win-win situation. Tell them what to do, prepare them ahead of time, enable them interface with the other party. When you get to the courtroom, the duty of a party is to convince the judge why the matter should favor them. But for the purpose of mediation, the mediation advocate enables his client engage with the other party. Many people, they fail where they miss it. They want to convince the mediator. You are not to convince the mediator. You are to engage the other party why you think what you are saying is right and what you are ready to let go of in order to accommodate their own position. So mediation advocate assists his own clients, who may be the claimant or the respondent, in intervening and interfacing with the other party for the purpose of peaceful and speedy resolution. So you can earn your fees, accompany your party for the purpose of mediation. You get your fees. Independent mediation negotiation practice, you get your fees. Most lawyers that are also ADRO practitioners, when the matter is for litigation, they get their fees. When the matter is for mediation, they get their fees. Either way, they are moving. Whether you are a lawyer or not, ADRO is for you. You can become an ADRO consultant. You can sit and counsel people, consult for persons. I think this is the best way to handle this issue. I think this is the best way to handle this issue. And as a consultant, you get your fees for it. Nothing goes for nothing. You can be an expert dispute resolution specialist. Your duty is to say you can dissect disputes and come up with innovative ways to see how it can be resolved or managed. Not all disputes can be resolved. Some disputes can be resolved. Some disputes are better managed. So either way, there must be some mediative minds that can forecast and do the needful. So either way, you can get your fees. You can be a trainer or a facilitator. What am I doing? I'm facilitating a section and I'm entitled to my fees. What is my qualification? I'm an ADR practitioner. So either I function as a negotiator, I function as a mediator, I function as a mediation advocate, I function as an independent mediator, an ADR consultant, an expert dispute resolution specialist. I function as a trainer, I function as a facilitator. I can get my fees. So you will agree with me that ADR is not an academic job in revenue. Learning and development, you must invest in trainings. Develop the act of continuous training. Take advantage of local training. Adopt volunteering services. All these and many more will help you improve your ADR skills. Don't forget, in the class I took on Tuesday, I said, what we have now will definitely evolve. So we must be at the cutting edge. An ADR professional is one that's always at the cutting edge. You're always reading. You're always developing yourself. You're always sharpening your mind. And you must creatively define and design your style. You must creatively define and design your style. The field is wide enough for everybody. So you must know the style that suits you most. So you can make money when you mediate on cases. As a mediator, you can make money when you represent your clients as a mediation advocate, when you act in the capacity of a consultant, when you facilitate trainings, you are entitled to your fees. I hope I've been able to do little just ADR services. My lords, your honors, your worships, highly esteemed physical and virtual participants, thank you for your time. I appreciate you all. Thank you. If we have some questions, we can just take note of them. Let's see how much time I have left. Thank you so much. I'm grateful. Mr. Nathan, over to you, please. Mr. Nathan, please.
Yes, so do we have questions? Okay. You know, this is where it matters. Yes.
Yes, my question is, I had Mr. Samuel said that the fee can be shared equally with the parties. So, no, our economic standing in life are not always the same. And there is no rule that only the rich will always have problem with the rich, the poor will have with the poor. Where you have a claimant who is poor, the respondent who is very rich, they are not at the same economic status. How would they share the fees?
Mr. Samuel, I hope you've heard the question.
I had the beginning when he was making reference to the fact that I said both parties need to share the fees, but I didn't get the latter part of it. So maybe he needs to re-echo that latter part of the question, please.
Can you hear me?
Yes, I can hear you, sir. I need to hear the last part of the question.
You said parties, the payment of the professional fees or the fees.
Yes. Yes.
If disputants, there is no rule that disputants must come from the same economic bracket. where you have a wealthy claimant and a poor respondent, how will you do the issue of sharing additional fee?
Okay, so if I heard you correctly, you're asking a situation where we have 3 claimants and 4 respondents. Did I hear you correctly?
Claimant and respondents, they are not with the same economic status. And you say
Okay.
that you ask them to share with you. Maybe one is a commissioner, the other one is just writing this, his bicycle card. It came to you for settlement.
Okay, thank you so much.
How do you go about that? Is it wrong, or is it wrong if one of the parties will just take the responsibility of paying the fees? Is it bad?
Thank you so much for your question. Now, let me add a little pep to that. We've had cases where we have 1 claimant and 9 respondents. There are matters you have 4 claimants and 1 respondent. The law of mediation, except otherwise stipulated by the documents that empowers the Dispute Resolution Center, parties share their fees equally, 50% claimants and respondents. But there are some exceptions based on arrangement of the parties. We've done matters where the respondent will tell you, I will make full payment for the session fees. We've done matters where the claimant will tell you, I will make payment for all the fees, so the respondent should not bother. We've even done matter between 2 brothers, an elder brother and a younger brother. They paid their fees 50-50. When they were done, the elder brother said he will return what the younger brother paid. So irrespective of their economic status, the fees by default is being splitted between the parties, except parties decide, no, let us alter the ratio. So if we have 3 claimants and 4 respondents, there's a matter I did, we had 9 respondents and 1 claimant. Only 1 claimant, 9 respondents. The implication is the claimant pays his own 50%. Why the respondent, the 9 of them will share the 50% among themselves. So you see, the percentage each of them will not pay. I told them, we are not looking at the number of parties that make up one side. What we are seeing is claimant and respondent. So irrespective of the number, irrespective of their social standing, they split the payment, except parties now decide to say, oh, let us alter the arrangement. I have personally done a matter, and I discovered that, like what you said, the social standing of both parties, the claimant could make full payment, but the respondent could not make payment. And the respondent said, I think I need to go ahead. Let me make payment and let us get on with this process. The claimant made payment, and in less than 1 month, we were done with the settlement. We were done with the settlement. We were done with it, and it was a beautiful scenario. A dispute that had lingered for over 2 years was resolved under a month. And this is where the skill of the mediator comes in. You should be able to read behind the line and know how to help parties adjust and balance. I don't know if I've been able to answer your question.
Yes.
Hello. Thank you, sir. My name is Douglas.
Is that your honor?
I have a question, but just a small one.
Is that your honor?
But before I go into my question, honestly speaking, Mr. Samuel, I just want to appreciate you. All the accolades given by the facilitator of this program, I think you understated them. You have this simple way of passing information across and knowledge across. Personally, from the inception of this program till now, your paper presentation or teaching has always been so simple. That is why all the time we always tell you over understand. Notwithstanding that we say rest inside the people, right? I have one question. One of the career opportunities you stated, you said one can be a negotiator, mediator, then a mediator advocate. Is there any criteria for one? Is there any, what does it take one to be a mediator advocate? You know, for you to be a counsel or a practicing lawyer, attended university, go to law school to obtain your license and get a role. And here I'm seeing again, mediator advocate. And I keep seeing your names, those suffixes after your name is CMC, FICMC, and all those things. You know, some of them have up to like 20, 30 characters. You know, I wonder how you obtain them all. I know I have to work for her. But how do I become a mediator advocate and any other thing you need to become here? What do I need to do to obtain these titles?
Thank you so much, Your Honor. I'm sorry. The first question I answered, I didn't take cue of the personality that asked the question. It may be my Lord or Your Honor, Your Worship. Please forgive me. I omitted that. Standing on all existing protocols. Your Honor, Mr. Douglas, I want to appreciate you for your kind words. And I must say that it's an honor for me to have this interaction with all of you because I'm much better whenever I end in presentation. Thank you so much. I appreciate you. Now, back to your question. We all know if I say I'm not a lawyer, but permit me to assume imaginary. If I say I'm a lawyer to an average man on the streets, sir, these are the learned people. Not lawyers are the only learned people. Oh, they are the learned. But to a co-lawyer, he will understand that even in the field of law, everyone has his own area of specialization. In the medical field, we have medical doctors, but doctors have where they specialize on, and some become consultant in a specific area. The same goes for engineering, the same goes for every other field. So as a mediator, at the end of this training, we are grateful to Shati for making this training come to reality despite all odds. We are grateful. At the end of this training, you'll be inducted as mediators because you've gone through the training and certification program. Now, to become a mediation advocate, there's another specialized training that can enable you become not just a mediator, to become an advocate of mediation. What it simply means is a specialized training that will enable you understand the nitty-gritty of mediation and how you can skillfully simplify issues that are very complex. When a mediation advocate walks into a mediation room, one of the things he does is to pay attention at the other party. Your focus is on the other party. What can I do to make the other party understand my position? What can I do to make my client understand the position of the other party? So your attention is not on the mediator, your attention is on the other party. There's a literature that says she stoops to conquer. How can I stoop to conquer and convince the other party? So it's a specialized training that helps you enhance your skill as a mediator to navigate difficult issues. So you want to become a mediation advocate. I'm glad that Mr. Natchang is also a mediation advocate. So he can The training usually comes up once in a year. So you can get in touch with him. The same way you sat through this training, that is how you will sit through that training. But it's not a 5-day training, it's like just a 2-day training to further help you dissect and understand what you need to do to become a mediation advocate. Like I said in my first teaching, mediation is a wide word. It's a very wide word. So I love the enthusiasm. You are a mediator now. You can progress to become a mediation advocate. You can progress to other areas based on your why. Your why will determine your style. Your why will determine your pattern. I think I should not have flogged that question. I hope I've been able to answer your question, Honorable Douglas.
Very well, very well.
Thank you so much, Your Honor.
Thank you. Thank you.
Okay. Do we have further questions? Further question. Okay, I believe that we over-understood, right? This is an aspect that has to do with payments, earnings. So thank you so much, Mr. Samuel. I will not appreciate you enough. I believe that my lords, your worships, your honors, all of them really appreciate you for a well delivered session. We are grateful. On behalf of the governing body of Settlement House, we want to say thank you and thank you and thank you so much. So
thank you so much, Mr. Nacha. Thank you, everybody. We are grateful. Thank you so much. I'm grateful. Thank you.
All right, thank you. So I think you can take your leave, sir, if you want to.
Thank you.
You see, there is this constant emphasis. There is a question. You have a question? Okay. There is this constant emphasis on training and retraining. If you know the amount of money that some of us have spent in training, you will not be surprised, because it depends on what you want to, right? When someone is paying you, you should know that you have done what is needful, what you needed to do to become to charge that particular amount, right? So take steps. If you don't have money to pay, you can go for online. There are some free courses actually online that you can do and add value to yourself. Now, when it comes to some other ones, you can look for resources and get yourself trained. And you see, it's not sufficient that you are trained and certified as a mediator. If you have opportunity, you attend training from other institutions, then you'll be able to know, oh, okay, this particular training was wonderful. Okay, they've not included this part, they've added this part. No training will give you all that you need. Even in Settlement House, we went out of our way to bring in topics. Like this topic, as we keep saying, it's not taught during mediation skills training. It's a specialized course that you need to enroll and pay for to be able to earn, to gain. The one we are going to teach you on how to start up your mediation practice is also a course that is paid, not part of emotional intelligence. Is also a course that is being taught. It's not ordinarily part of mediation skills training. We have done and we are done with those aspects. But this is an aspect that, we feel is going to add value to what you are doing. More so, you are going to go out there after
you qualify for induction and you are inducted and admitted as associate members of the institute, you are going to go there as a mediator. So you have opportunity to learn, but that there are basic important things that you should not miss out. So you have become a lawyer. We know we have junior lawyers, you teach them and guide them, but there are basic things that they are supposed to know and learn well in school and well in the law school. So these are very, very important. So we are going to be having session on continuous professional development for lawyers. We see that even though we don't charge for now, except for those who want to have certificates as to show for sessions, trainings they have attended, we don't charge, it's free. But it's surprising that a lot of people don't still attend even the continuous professional development training. You see, it's to your own advantage. If I have opportunity, every year or seminars I attend, because you are going to gain one thing or the other. You may not have opportunity to go and carry books. If we give you books on mediation to read and read, you get tired. You may not even make sense out of some of them, right? But you see, this training has given you opportunity to learn, to ask questions. Some of these things that you would have been struggling to have been summarized, isn't it? And you are able to get them straight away. So this is the importance of attending trainings at all times and at all levels. So thank you very much for that session. So with now, I think, do you want us to go into the practical simulation or to take our lunch first, then come back and do and take the class? Or you want us to take the next class, then go for our lunch? Our lunch is ready. Depending on what you want, we can go for the lunch now. We can take the class, the last topic, then we just know that we are going to practical simulation, or we can take the practical simulation before lunch, we go for lunch, depending. So let's vote. What do you suggest? What's on your timetable? How long is this supposed to be? It's 1 hour. Yeah, so we can take 1 hour if you so wish. Let's take a class. Is that okay? Let's vote. What do you think? We should take lunch? Pardon? Lunch. Okay, we are going to vote then. Some are saying we should take the class, some are saying we should take lunch. If you are for lunch first. Lunch. 1, 2, 3, 4, 5. Yes, 5 for lunch first. Then is it for class? Okay, for class. Okay, so we have 5 against 4. So let's go for lunch, right? We can do quickly. Let's utilize our time. Let me tell you, if we are organizing a practical session and you need to attend, you will pay for it. But this is your training, and you know the amount of the training, just 200,000. It's not up to what we are giving you. So if you want to take advantage of your time, we are all here. I'm here. You know, we do trainings. If we can organize it customized after you have been certified. If you want more practical session, we can organize a practical session at the fee. We will get parties. You will serve as mediator. We will train you. You pay, yes, you pay for it. But this time is your time, so you can enjoy it. So if you want to utilize it at your own, if we say let's close now and go, we don't lose anything. We have done what we need to do.
You know, we have about 4 practicals plus the ones that are taken during lessons. You know that you have done enough practicals. You cannot go out of this place and become like a novice. Yes, you can't be a novice. Right? So you will go there as someone who has knowledge of the mediation process. Are we together? So if you can go and take lunch, if you want to take like 15 minutes, 20 minutes, then we can take the next class before going for practical. That will be fine. Right? Is that okay? So let's go. Please, our lunch is ready. Let's take the lunch. And then let's refresh at least. We have been sitting. Then we'll come back. Thank you. See you shortly.
Yeah, that's good as well. It's off now. I just on it. Okay, so we're taking the last class for today, and the topic is starting your mediation practice. Having established all that we need to know, starting from the general introduction to starting from the general introduction to the various aspects of the things that we need to know, your mediation skills, understanding personality types, emotional intelligence, the various stages in mediation, conflict analysis, effective communications, having done all these courses. Now you have also learned how to charge, because you are not left with, okay, if somebody comes to me, how do I charge? So you also now know how to charge. But it is one thing for you to be trained. It is one thing for you to become a professional. It is one thing for you to now start something that will be known, will be recognized, such that people will start looking for you. Now, aside from training, in the course of training, I don't know how many of you have networked with one another, that you're able to get the name, phone number, place where some of the participants are living. That's one of the powerful tools. You are trained together. Tomorrow you may have a matter, and maybe you are in Zaria, or you're in Kano, you are in Lagos or London. Say, oh, I remember I have a mediator who stays somewhere in Kaduna, right? So, but if you don't network, how are you going to do it? So you need to understand some of these things, so that when you want to start up a practice, like you are now certified, what do you do next? What next? We don't want to leave you just like that. You go and start gambling and struggling. Some of you, most of you, almost all of you, with the exception of like 3, are actually judges, caddies, Sharia court judges, alkalis, and the rest. How do you start up a practice? Can you actually do a practice of mediation in combination of what you do? When people are looking at you, oh, you are a judicial officer, you are a judge, you are this. Can you actually combine this? Certainly. But you need to know what and what can you do. As I've stated earlier, you need to know what you need to do. So now this is it. Now that you have been trained, let's say you succeed in your assessment and you are now certified. You are not certified. What next? What do you do? So you look at, for the fact that you came here and you stayed for 5 days, training and learning the skills to become an effective mediator, what do you need to do? What are the things that you need to do? comfortable with
Anyway, so these are the basic things that you need to do from now. Number one, you need to have a vision. Number two, you need to have your goals. Number three, you need to have your target audience. Number four, you need to have your business plan. Now you see, it is not a waste of time that you have come here and stayed for 5 days. Some of you, in your stay here, it means you have not been sitting as a judge that you are. So having stayed here for all this while, what is the next step for you to go? So what actually inspired you to come and stay in this training from the beginning to the end? I know some of you did not even miss any of the session from the beginning to the end. What inspired you? What is the motivation? Why did you come to stay here? Did you come because you are asked to come here? Did you come because you have an interest? Did you come because you want to pursue a career that will earn you a living? Or you just came to fulfill all righteousness? Why are you here? If you cannot answer these questions, it will be difficult for you to start a successful practice. Now, what is vision? Who can tell me? Vision. What is vision? What is vision? Is to have a clear picture of what to do, either in the near future or clear. You have something clear that you are pursuing, and you hope to achieve. You hope to do it either in the near future or later. Okay, do we agree with you? Or somebody wants to add? Remember seeing the very fast occasion of vision. What define vision as? Foresight, insight, based on insight. Foresight with insight, based on insight. It's a very short. Foresight based on insight. Foresight with insight based on insight. Can you break it down for us? Okay. Foresight, as we said, seeing the future, seeing ahead. Yes. Oh, seeing ahead with understanding that, not just seeing ahead, but you have the understanding of how to go about what's ahead. And then based on, you say insight. That insight is, a four-legged animal. That legs behind enables it to jump. So you understand that's stamina that enables you to pursue what you have seen with understanding. Thank you. Doctor wanted to say something. Vision is an understanding of the truth and driving your goal towards the aspiration of the future. And all those things in between that makes the realization of the future possible, putting into action those dreams that will make the realization of the future possible. So it's a drive towards the future, using the arsenals to have at your disposal to make that achievable. Okay, thank you. Thank you, thank you. You have made my work easier. When they blow the drama, please, you break it down for us so that we we can be following. So you see, you have undergone the training, you have obtained stamina for now, isn't it? Now, do you know that if you don't have a vision, all these things you have learned, just give it time. You will even forget that you have attended a training of this nature, isn't it? So what are you seeing in the future? Do you know that mediation and ADR is going to take over the future of dispute resolution, not only in Nigeria, in the world at large? And the earlier you begin to key in and begin to foresee the future and prepare yourself to dive and follow and acquire all the relevant skills, abilities that you need in order to survive, then you are going to be left behind. Are we together? So now that you have been trained, what is your vision? What do you want to pursue? We now have the mediation and the arbitration and mediation Act 2023. Initially, we do not have any law that mentions mediation, especially nationally, that regulates the practice of ADR. Now we have it. You have been taught that there are laws, both religious and legal framework that regulates ADR. Haven't learned that, and some of you are judges. What is your next step? What do you want to become? Write these things down so that you can have a roadmap. I know that I want to become a mediator. Is it only in Kaduna State or in your village? Huh? Or, you know, in all the states or globally? It is your vision that will determine the kind of preparations that you are going to make. Right? So now, having established a vision is future, right? You have seen the future, you have a proper understanding. Now, what are your goals? You can have short-term goals and long-term goals. Now, for the time being, I want to go through all the trainings I can go through. It will be your goal for now. I want to attend all the seminars that is on area. I want to get certified in mediation, arbitration, mediation advocacy. I want to get certified as an area registrar. I want to acquire knowledge. Now, from now till so time, I want to begin to practice. I want to make my skill effective. I want to, through repetition, become a skilled area practitioner. Those can be your vision. You can have your vision, and then these are your goals. The short-term goals, and then the long-term goals. All of them are working towards the future. Some people will say, what is your mission statement? What is your vision statement? And all of those things. You will come and see them in your business plan. Now, having established a vision of the future, and you have seen it, you have an understanding of what it is, and then you set down your goals, the things you need to be doing, whether temporary, you know, or long time, in order to achieve and ensure that you have entered into, you know, or bring your vision to actualization. Then you need to sit down and check your target audience. Do you want to reach out to? If you want to be a mediator, like I am a mediator, I'm an arbitrator, I'm a negotiator, I'm an area registrar, I'm a conflict manager, I'm a restorative justice practitioner, and all of those things in the area of area. I am a trainer, I'm a facilitator. You can decide to say, okay, I want to concentrate on the aspect of facilitating. I want to become an expert, a consultant. I want to become this, I want to become that. Is going to make money enter your pocket. Who do you want to convert to see this thing that you have done? To begin to engage your services. Who? Are we together? So you cannot just get trained, collect the certificate. Yesterday they brought my certificate. I was an associate of Nigeria Institute of Chartered Arbitrators. now I'm upgraded to a full member of the Institute of the Nigerian Institute of Chartered Arbitrators. You progress, isn't it? Based on your vision. If you hear the money you pay for trainings, you'll be like, what? Isn't it? So, but you invest in yourself. That is the thing. Invest in yourself, and your investment is not just anyhow. You are investing because you have a vision and you have goals, and that you are pursuing them what? Vigorously. So I have a car which I rarely use. In fact, I don't like using it. I have a bike which I always like to use. And then they say, this is a lawyer. What are you doing with bike? This, and that. You know, they will be saying all manner of things. You should go and buy maybe a car or be moving around. If I want to do it, fine, I can do it, isn't it? But your activities are regulated by your vision. I am more interested in investing in myself for now because I'm still young. When I get to certain age, I don't need to struggle anymore. The things I've invested and the seeds I've sown, I will begin to what? Reap them, not only just 1, 2, in 100 folds. Because I have a vision. I want to be known as an area practitioner in Kaduna State, in Nigeria, and in the world at large. And that's why when you see, during my time as the executive director of Settlement House, I try as much as possible to establish relationships, bring in faculty members all around the world. Now you can see that from the training, you have trainers both within and outside Nigeria. They have shared with you perspective from Nigeria, shared with you perspective from some states of Nigeria, shared with you perspective from United States of America, shared with you perspective from the United Kingdom. So that you can be a balanced practitioner. You will not be a, what do you call this one that you see the stomach bigger than the head, with the head bigger than other parts of the yeah. No, yes, you will not be malnourished. What do you call it? Washoko, is it English? Huh? It's English word. Wow, I thought it's outside they just, you know, the way we used to. So you see, be a balanced practitioner. That's why we bring in all of these people, so that you will be exposed to some of these people. You know that there are area practitioners all over the world, right? The person that spoke to you last, that's Mr. Samuel. He's not a lawyer. Do you understand? He's not a lawyer. Mr. Isaac Asare from Ghana, that is one of our faculty and neutral, he's not a lawyer. Are we together? Catherine is a school teacher who abandoned the profession of teaching and went into mediation full time. She is not a lawyer. Are we together? So you as lawyers, you have double advantage, because when clients have issues, the first call is you. They come to you, and the rules of professional conduct under section 15, sub 3D, right, clearly states that you have a professional responsibility to explore ADR. It is when all of it fails before you resort to court. And this is what you have at your disposal. So you are better equipped and at an advantage position more than every other person. Are we together? So, but you know, a man without a vision, it's like I told you about some of these friends. You just be going like, boy, how far? Where are you going to? Say, I want to go and check. You were going somewhere. Where you're going, I'm following you. Say, let's not go. You know, he doesn't have he doesn't have vision, he doesn't have idea, he doesn't have goal, anything else. Have to be deliberate once you are pursuing and doing. That's what we're trying to see. So you see, these are the basic things you must put in place. Now, you know what a business plan is. You must know that Your vision determines the type of practice you do. You may say, oh, I've learned now, I want to go and make impact in my community. I want to do community service, free services. You can decide to say, I want to do services that will earn me money. I am a businessman like my mentor. He says, see, he is a commercial mediator. He is out there to make money. If it is not making money, it is not making sense. Simple, that is his slogan. So if you call him for a training, you pay. If he's doing mediation, you pay, because that is what he's going out for. But you see, you as a new practitioners, you must look for opportunity to volunteer your services so that you can learn the skills. When somebody comes and is hiring you, he's not hiring a hand that is not well tutored. Remember that we kept emphasizing that if you are unable to make your skill become professional, you can frustrate a lot of sessions in mediation, and that will not be the fault of the parties, to be your fault. Are we together? And your appointment as an area practitioner is based on the party's discretion. So they must see this person is interested. They have to. So you have to write down your business plan, go through the components of business plan, write it down very clearly. You know, carry your vision, your mission statement, your goals, your aspiration, whether short time, long time, all of them, let them be properly written. Are we together? So that in case you miss direction or you have forgotten, you can go back to what you have already written. Are we together? Then after you have done this, you know, you must build a team around you. You cannot be a solo practitioner. You cannot be a practitioner and survive alone, right? You must network. You must know other people that have similar interests. You must know other people who have advanced in this career. People, you know, emotional intelligence. They say you should take advantage of a relationship, right? What are the components of emotional intelligence? Self-control, self-awareness, awareness of others, and then building relationships, isn't it? Now, if you don't know yourself and you don't know others, you will not also know who to reach out to when you are in need, or when you need to appoint someone, or when you need someone that is going to do a particular something, a particular thing for you. You will not know. Are we together? So you need to develop that network, develop a team. Oh, if I'm going for training, if I'm going for a mediation session, I have support staffs. I have people who are going to help me. Are we together? So, if you say you need a team, why do you need a team? You cannot do it alone, right? You cannot do it alone. That is why you need a team. Now, if you look at what should you look out for when hiring or looking for somebody, you need to look out for somebody who is diligent, right? You know, if you are going to go into training, possibly you need someone who is proficient in typing, who is proficient in preparing slides, who can manage some of these equipment, you know, or you hire somebody and train him or her to be able to do some of these things, because you will need it. You need somebody who is up and doing. Are we together? Someone who has skills, diligent. It's not someone that, you know, you have people that when they prepare something for you, you will know that definitely you will need to go through it properly and put it in order. That's lack of diligence, right? But if you have a diligent person and you say, prepare this thing for me like this, you know, even without going to it, you know that you will do something for you. So when you are building a team, you must look for what? You are building a team, hire people who get connection or relationship with people who are diligent and they are skillful. Skillful in what they do. Look at some of these things we are doing. We are doing a physical training. We have online participants. Isn't it? Now, you see, we have almost like 4 phones. There are phones that are going to be used for data. There is one that is going to be used for the video. There is one that is going to be used for audio. There is one that is going to be connected to the system. You know, you need a lot of things. And you need people who are skillful in those areas, depending on the aspect you want to go into. If you want to form an, you want to open up an office and be a mediator or resolve disputes, you need a secretary or an assistant who is able to do some of these things, right? Oh, somebody comes, he can take the complaint, he can discover, okay, which type of area of dispute, what and what is needed, you know, give out the form, fill the form, do 1 or 2 things, and then reach out to you to say this and that. Skillful. Of course, you don't go for people who are illiterate. Isn't it? It's people who can fit in and help you achieve your vision, your goals, your aspirations. And then you need people who are passionate. Someone can be very skillful. Someone can have the education and the diligence, but is not passionate about what you do. So you are going to have a problem. But when you see someone who is passionate, he takes your business as his own, then you are rest assured. These are the type of people that you bring into your team. You know, you must possess technological, they say connect to Zoom, say, Kai, this Zoom, sir, I don't even know how they used to. How do they used to connect it? You will connect. You did not want to go to, the thing is not working. You say, this thing, I'm not hearing anything. You keep sending messages on the Zoom. It is not working. It is not working. It is not working. Are we together? Then now you have known why you need a team. You have also seen why what you should look out for when you are hiring. Is it rain? Prophet. So why should you put in what should you put in place for your team? You should have organizational procedures and systems. If this person is in charge of training and they call you, okay, come and deliver a seminar, so maybe you give the points. There are people that may be into research. You say, oh yeah, you go for research. You have someone who will, when they research, he will type it and arrange it and send it to someone to prepare the slides. If you have that kind of procedure from this person, okay, in the absence of the boss, who should be in charge? If you are to give, you need to approve something that, okay, we have prepared this thing, who will take a look at it and say it is okay, or guy is not around. You should have some of these procedures so that you don't need to stress yourself. When you are not around, somebody else can do certain things. But if you don't have structures, they will wait until, imagine you travel to a place where there is no dispute and you have an office, people come here and file their complaint. They are reaching you, trying to reach you on phone, they cannot reach you, and there is nobody that can take decision on your behalf. Nobody can take steps, right? So that is what you should put in place for your team. So that with or without you, you can put a structure. Once you finish this, send it to so person. If he gives you the approval, but you see, you have to train them. You need to train them so that they will know your tests. They will know your what you look out for. Do you understand? You can train someone to a point where when he begins to write or speak, he will be writing and speaking like you. You have to invest in their training. Now, one important thing you need to do also is to build a brand for yourself online. So, if I see the internet, will I swear? Yes, please. I would like it. Isn't it? Now, what about you? Definitely. So, what did they know you on? What did they know you for? What did they know you? Even your friends, what did they know you for? As a legal practitioner. I see to which type of practice? Public practice. Public practice. So can you see? Now, if you say I'm a legal practitioner, you have different areas of practice. Isn't it? So build a brand where online. Your brand, like sometimes, sometimes you just see us with a t-shirt, settlement house media training, and somebody will ask you, this one. Which one is this? It's a brand, isn't it? But we're talking about online. Some of us do WhatsApp, Facebook, LinkedIn, Telegram, and all of those things. When you go to some of these social media platforms, remember your target audience. If you have target audience that are online, you have to build visibility and the brand online. They will have to come and recognize you as a mediator. When someone is searching for mediator from the UK, they are looking for a mediator, and they search the internet and they say mediators in Nigeria. Will your name come out? Yes, because you have to build deliberate a brand where online. Because most, if somebody wants to find out about something, where does he go to? Online. You go to Google. If they say, what is something you've not had before, you can go to Google and find out. Are there mediators in Nigeria? Are there mediators in Kaduna? List of mediators in Kaduna State. They will bring the one that can find. Isn't it? So you need to deliberate the work, the brand for yourself online. So aside from online, you can also do a brand for yourself where offline, depending on your target audience. If your target audience are those that are not this computer generation, they are the older generation, then you now know where to channel your interest. You must do physical issues, physical things, physical meetings. You reach out to them verbally, discuss with them, do flyers, do seminars. You need to attend trainings. Right? You see training seminars all over, you must attend. In attending, they'll say, oh, what do you do? Say, I'm a mediator or I'm a lawyer. People get to know what you do. Now, by the time you are trying to put a brand on offline, not online now, offline, they must know you. Maybe if you can decide to begin to wear things, do things, maybe this thing is yours, you customize it and put your name, the mediator, the area practitioner. So when you search for me on WhatsApp, you will see Nanchang now. But if you go to my profile, you see a lot of things that have to do with it. But physically, what people can see, my pen carries the name of my office. Isn't it? Mediator, mediator Joshua, mediator this and that. start doing branded. When your clothes, you can do your clothes and put something that brings people, help people to see the future in mediation, that will make people to ask you questions. Like if you see our slogan, we resolve disputes and we teach you to resolve your disputes yourself. That's what we have. That's our slogan. Are we together? I don't know whether the online participants are listening to me at all. If you are, please.
We are listening, sir.
All right.
We are listening, sir.
All right, thank you. So now you see, if you are doing business, if you have a business card, have a business card, brand it. Let it carry, you are a mediator, you are a negotiator, you are this and that, your t-shirts, your shirts, your tags, your car, put it there. Yes. I think it was Ambassador Shehu that used to put on his car. He said, that trouble and my work. Trouble and my work is a brand, like stickers in his car. Isn't it? Lawyers, what are the type of things you put on your car? Maybe your logo, isn't it? MBA logo. You will see the one, lawyer, they pass. You never see that. Eh? They have seen it, but what are the other ones you should see? Eh? My wife is a lawyer, don't touch. What do you mean? My son is a lawyer. Isn't it? Yes. So you see, you have some of these things. What are your own brand? You can count your own statements, things that you can customize, so that when people see physically, they will be able to say, yes, this person does this. Now, offer quality services specifically targeted at your what? Unique audience. If you are going to reach the younger generation, if it is the older generation, people who know the internet and those who don't use the internet, if those are your target audience, you must begin to what? Offer. Maybe you can start offering seminars. We do seminars, we invite people to attend even for free. Attend this seminar. They are not charging you, but people are not attending. But you have to be deliberate. It's not going to be easy, but your vision is what is going to motivate you to do all of these things. If you don't know your target audience, you are going to just be doing everything. You can concentrate on saying, I want to resolve disputes in the church between Christians or between Muslims or commercial disputes or construction disputes, and begin to target people like quantity surveyors, building engineers, civil engineers, all these people that are within the realm of what? Construction industry. Those are your target audience. Once you have defined them, are we together? Now you need to educate people about what you do, your mediation practices, the services and the things you can do for them. Now you must go to your church, your mosques, your NGOs and the rest of them and begin to organize seminars. You can invite us. You can do online seminars. You can do physical seminars in meetings where you help people. If you talk to an audience like this, tomorrow, if any of them have an issue, they say, that person that talked to you about this, is he not the better person to reach out to? Since I have this problem, this and that, I say, oh, okay, you can resolve it through so means. But if they don't know you, so you must take steps, you must do things that will make people to know you, build your brand. Educate people about the services you do. It will be surprising if I ask Ajia here, who is this person and what does she do? You say she doesn't know. Do you know what she does? Do you know her name? Do you know what she does? What's her name? What does she do? Huh? She's a judge. You are sure? Aha. So you need people to know in your environment when you go. If you like, you can go. You know there is no restriction in this thing like legal practice. I am a mediator. If you like, you are the best mediator in the world. Nobody will go and you understand. So when you build your brand, let people in your environment, in your home, anywhere you go, advocate, preach this thing. If you are an imam, or you are a pastor, or you whatsoever you do, you cannot do anything without saying, praise the Lord, or praying for people, or calling the name of God, or some of those things. They flow naturally. So anywhere you find me, if I'm talking, ADR, mediation will come inside. It has become part and parcel of me. Let people around you get to know what you do. Sometimes somebody is looking for a solution that is there before you, but it doesn't know. Who will make him know? You. So when you finish the training, let your family members. Business starts from family. Business succeeds when family and friends pay for the service. Isn't it? Isn't it? So your WhatsApp contacts, your family and friends, reach out to them. Strive to be the best mediation practitioner in your niche. When you say, I want to go into construction, you see, some of the profiles you read, we are not just reading them for reading's sake. We want you to see what some of the people that are coming to stay here to talk to you, what they have done in trying to build a career for themselves in areas they want to be recognized. Are we together? So it is intentional, it is deliberate, so that it can provoke some of you to say, oh, so I want to go into family mediation. Maybe you are not happy how marriages are breaking down here and there, and you want to go deliberately into family mediation to see how you can contribute your quota. It can be free, it can be paid. It all depends on your vision and what you are pursuing. Are we together? So, but you must strive to be the best where you are. Are we together? Strive to be the best. Volunteer your services. Very, very important. So that people will get to know that you can do it. If you don't do it for people, as I told you, if I want to volunteer to teach English in a school, they may accept me. But if I say employ me, they say, sir, you know, we cannot employ a lawyer now. We don't have the money. In fact, we are not looking for a teacher. But if you volunteer, they will accept. They will even give you tax you never imagine. From there, you get to know about the school. You contribute your quota. People will get to know you as you are having an audience and speaking with them. You are bringing about how to resolve your dispute peacefully through mediation, arbitration, and you are a mediator. The children may go and tell their parents, say, my teacher used to resolve disputes for people. Right? Take advantage of those things. Now, online dispute resolution, things are going online. You can see that. Assuming we are going to sponsor Mr. Lloyd from United States to come to Nigeria and take this class, do you know how much it will cost us? Flight ticket from here to here says how much? Who can tell us? You have an idea? Is it 100,000? 200? Is it up to 200? More than? Million? For where? To US? 750? 750,000? Okay, so imagine, where do we have the 1 million? If you can, assuming all of you pay to 200,000 naira as you see on the season, how much will it be? Maybe flight ticket to and fro. Abi, for one person. What of Kathleen? What of those from the UK? How much are we going to spend? But you see, online dispute resolution, online platform has made it easier for us so that they can stay there and deliver their class, they can be asked questions and as if we're interacting physically. Are we together? So now, do you know that we can resolve disputes through online? You see this Zoom, you can have a complete mediation session on Zoom. Are we together? One party is in England, like we were discussing, these people are in US. Kadim was in US, Kati was in UK, right? We're in Nigeria and we are having conversation as if we're in the same room. That is what online technology has done for us. So if you want to be known, you must find yourself in this area. They say ODR was born from the synergy between ADR and ICT, because ADR has a lot, you do a lot through ICT. So they said, as a method for resolving disputes that were arising online, and for which traditional means of dispute resolution were insufficient or unavailable. For example, now, let's say there is a dispute between Lloyd and Cathy in US, and you are appointed as the mediator. Then you say, where are we going to be? Let's meet in Nigeria. Then they will spend like 1 million naira to come, you know, or 1 million or 700 to come and then go back because you want to have a mediation session. Can you imagine? You can see, but this has made our work easier for us. What is the benefit of ODR? It helps to resolve issues that are cross-border. Not like lawyers. Can I go and practice in? Do you know that you cannot go and practice in US as a lawyer without being called to their bar? So you cannot practice in Nigeria without being called to Nigerian bar. But mediation is all round. They can appoint you from anywhere and you will sit and mediate your dispute. All you need is these skills. That's why people who took you major part of this, most of them are not Nigerian based. They give you a perspective that is international. Some of them, like Lloyd is the president of Mediation Training Institute in the US, Florida. He's an expert that is a lawyer and a mediator that has been practicing for several years. If you go and browse Mediation Training Academy, the Mediation Training Academy on the online, it will bring the website, you look at it, a very elderly, if not a visiting professor in some universities. Are we together? So this is what it has done. It allows for convenience. Like some people, the grandparents were not able to come and attend physically because they have engagement, but in the little time they have, they connected where? Through online platform at their convenience. So they will be in their house. I've done trainings that I don't need to go anywhere. They will do certification training for you. They will create group. Okay, Doctor and Hawa were online yesterday, right? They did their mediation simulation online throughout. Their practicals were online. What is the platform we use? Technology. Now, when you use online, you see that even in the multi-door courthouses, they will assign a matter to you. A party will be in Lagos, another one. Do you know even within Lagos, there are people in the mainland, there are people in the underline. They have that before you can cross to the other side to take you several hours. But do you know technology is the connector? You can just stay in your house and do a Zoom meeting. Very soon I will not be going to the office. When you are in the office, they will just connect the Zoom meeting. I will stay where we have meeting interaction as if we are together. That's what technology can do for us. And when that begins to happen, you see that people will not be going to court. It will help reduce the burden from where? From the court. Are we together? So now you need to develop yourself physically and virtually. Now, aside from these aspects, I want to concentrate some few minutes on online presence. I've connected with a lot of people and the activities of media, from conferences, from LinkedIn. How many of them are on LinkedIn? Are you active? So one of your assignments will be to go and open up your LinkedIn and make it lively. What I'm the fact that you are trained, the way that you are certified anyway, and saying you are a mediator, right? Because LinkedIn is a professional platform. Facebook, all these social media platforms, if you want to develop your practice, you need to utilize. Some of you don't have up to 100 contacts on your phone. More than. It means that those 100 are there on WhatsApp. Mostly. So it means that if you send a message on your WhatsApp update, people who do your status, you will even see and know. Imagine you begin to promote area. Do you know you can resolve your dispute peacefully through mediation? What do you think mediation is? Some of these first things you will start with people. If you cannot convince your neighbor or family member to see reason with what you do as a profession, patronize you, how can you combine outside? How do you combine it? Are we together? So those things you have, WhatsApp, Facebook, some people just go there and drop messages. And WhatsApp is an official listing. I do official discussions. We'll be discussing instead of just chatting. I do prefer WhatsApp and text messages. What do you use your own for? Your Facebook page, Telegram, and a lot of advantages you can use those things for. People need to get to know you. If you gather your skill and you just stay in your corner, nobody gets to know what you do. Nobody utilize yourself. Are we together? Are we together? So you must have vision, you must have set your goals, long term, short term, right? You must build a network, team for yourself. Are we together? If you have a business plan, except if you want to go into business, you want to be part of the money, and go into that. But it will be part of your business. I want to make impact. 100 people, I want them to know all these crises that we are having, whether religious or economic crisis or political crisis, all this. You know that election petitions can be resolved in India. Let the parties, let the people resolve. You can discuss. You can decide to go into political resolution of political disputes and build a brand for yourself. You are already a lawyer, maybe you are doing election petitions. You say you are conversant with that area. Then you now say you resolve political related disputes. They say this person is an expert. They will look for you. Are we together? Are we together? So when you go to the internet, when you have some space, put in your name now. Browse your name, the internet. Browse it. Then what do you do if you have the ability to do your website? You hear me? If you have the ability, you can do the website. The website will allow people to have access both within and outside. When you are talking about with people, they say, can you send me your website? Let me check. You say, I don't have a website. If you open a business that is ADR inclined, what should you do? Get a website for it. But if you don't have a website for now, use those social media platforms. Now you see, Settlement House, for example, we have a website. And if you go to our website, you have an idea what we do. You have idea what we do. What do you see? Our homepage, you see about us, our ADR services, our trainings, our gallery, our blog, our membership. So when you go to About Us, you see the type of things that we do, right? Look at it. You see, this is it. What is our vision? Can we go on? Where can we say? Read it. This is our vision. This is what we are pursuing, right? But in order to achieve that, we have our mission statement. You can see it there. Are we together? Our mission is there. We want to ensure that very soon this our training we translate it into Hausa, into also other languages, so that people who have English learning disability can also learn in their mother tongue. Maybe some of you can volunteer to offer these services. When our manuals are there, you translate it into your language, and then you can be trained and become one of the faculty members. When they want to do area training, imagine you have someone who can teach these things in your own language to the people that you are targeting, the target audience. Our vision, we want to do it in different languages, and then we want to have, this is our mission, things we are going to be doing, small, to attain to what we are going. We are going to have what? We are going to provide a platform where you can file your disputes, affordable, accessible, a place where people can put their skills into practice. The ADR center is there, an available venue for affordable venue for what? For coaching, mentorship, training, and practice. That is our mission. Now we say we are going to be collaborating, providing developmental consultancy, and then synergies, and to collaborate with local, national, and international educational institutions and organizations for the purpose of promoting literacy and eradicating illiteracy by the provision of an inexpensive platform for easy and easy access to quality education. With that, now we have started running PTE program, professional diploma in education program, from Institute of Education, under the Focus College of Education. We are running it. We are running NCE from Nigeria, from Gidonwaya, Kaduna State College of Education, Gidonwaya. We are running the NCE. Are we together? This is your vision, your mission. That is what gives you direction. That is what gives you the strength to pursue. When you go back and you look and say, oh, I've not started anything in this area. I've not started anything in this area. It gives you. Then you see what are the services. These are, you can take an example of this and do something so that when they search for, let's say you want to open Douglas ADR services, and they search for, say, oh, you do ADR, can you give me your website? Let me check. Oh, I don't have. Okay, give me your WhatsApp, your LinkedIn or social media. When they go there, just see your picture, you are posting like this. You are doing like this. Oh, I'm in England, I'm in London. It will not tell anybody anything about what you do. Isn't it? Except that you are having fun, you are traveling here and there. But it will not tell you what you do as an ADR practitioner. So you need to go and customize your social media to be deliberate. The type of information you'll be feeding there. Remember, these things don't like years after. When something happens, they will not bring one picture and say, look at our guy is here, look at him here, see this thing. Are we together? So that is it. Our ADR services are there. Look at, we are going to, under the ADR services, we have our panel of neutral, which we have shown you. These are people that are experts in different fields. If you have a dispute, you find it, we will go here and look at their profile and see the one that can what? Help you resolve. If you have a religious related matter, you have people who are religiously inclined. I'm looking forward to some of you taking up the steps to ensure that your name is included in as panel of neutrals when you satisfy the requirements. Are we together? Now look at our trainings. This is the training we do. Domestic arbitration, collaboration with educational institutions. You have to be deliberate. When someone goes to your website, you should see that you know what you are doing, right? If you don't have this on your website, your LinkedIn is a good place, professional place to have all these things listed, right? Online dispute resolution, we do trainings in it. We have Christian ADR skills training. If you want to resolve dispute through the Christian, dispute resolution and mediation skills training is the one you are undergoing now. Emotional intelligence training, mediation advocacy, the one you are studying you about if you want to become a mediation advocate. Training in negotiation skills and techniques, these are things that we do. Arbitration advocacy. You know, you have lawyers that represent clients in arbitrations, isn't it? Yes, just like mediation. And you have training on restorative justice. We are aware of that. Arbitration, arbitral registrar and secretaries training. And then you have training on construction industry dispute resolution. You have training on medical dispute resolution. These are the trainings we do, and look at our faculties, right? So somebody will want to go and find out, do you have the capacity to do what you are doing? Do you understand? They want to go and check your faculty. They want to go and check this and check that. So you give them some of the trainings that we have done. They are there. If you check it, you know, some of the online certification, you see if it is the Zoom training and certification, you will see them there. You see the pictures. The physical one we have done, they are also there. When you click on them, you see various pictures, right, of the things we have done. Somebody will want to say, you know, Nigerians, when they talk, but this is something that is global. You can access it from everywhere. People want to see what you are doing because they don't even trust Nigerians enough, isn't it? Right? So these are the things you will look out for. The blog has to do with articles. So some of you can write articles. We'll publish it on the website. ADR related. We'll publish it. For now, we have maximizing value, soft negotiation skills to create value and make your counterpart want to work with you again. These are things you can visit our website to check. Enhancing a just and peaceful society. The use of mediation to interrupt the circle of violence in Uganda. Non-verbal communication in mediation. These are all articles. You know, people will go there. We have categories of membership, right? We have full members. If you want to become full member, you can go there, click and make your necessary payment. You have fellows, you have full member, you have associates, and you have what? Student members. These are all. If you want to contact us, then our study centers, you see it. This is it. You have the NCE program. If you want to run it, that we do, you can see it there. You also have the PDE. Then if you want to fill the form online, you can just do so. So you can see our vision, our mission statements, and you see some of our activities are all what? In line with what? Our vision and what? It's in line with our vision. So you must not be saying one thing and be seen to be doing another. You must be deliberate in the type of things that you do. Are we together to this point? Any question? Let me appreciate you. This that we have done is developed by one of the faculty members, very young, passionate lady for ADR. She developed this outline and training. Her name is Loretta Onwuegozi. If you can help me call it properly, that would be good. Are we together? So this is it about ADR. Do you have questions? Sorry, you see, we are taking our time. We are taking your time as well because we want to see how we give you what we can. The next time you come to attend, you pay a lot of money, isn't it? Want to give you the opportunity. Yes.
Sorry, I think I'll check you back. Before was presented by partner. So this terms partner.
Said?
There were these terms used yesterday.
Partner.
Partner.
Yes.
Acronyms.
Yes. Yes.
I was not going to complete that.
You don't know
Yes.
what they are.
Yes.
Who knows what partner is? Yes. Okay, now or what partner, what? So you have best alternative to a negotiated agreement and worst alternative to what? A negotiated agreement. Are we together? The worst, like you are going, we are not negotiation skills, isn't it? Now when you are going, you prepare your partner and your one, isn't it? Now, what is the best alternative to a negotiated settlement? You are thinking I go and I'm not able to, or if I'm able to achieve, and I call it this is the best I do. Remember, we say you should be prepared. You must know what you are going for, you must know your limits, you must know all of these things. What is the best alternative? Now, assuming you go and you don't settle, you are not settled. What will be the alternative? Will it be a best alternative when you are not able to settle? Then, in your worst case scenario, your worst alternative will be negotiated agreement. What will it be? Maybe the offer you 10 million, and you look at it and say, ah, if I want to go with this 10 million or not. Isn't it? So you look at it. Assuming I don't take this thing, what will be my worst alternative? Okay. All right. What will it be? To go to court, you spend how long? Will I be able to get to now? How much am I going to spend in the litigation? And when we begin to go through the stages of appeal at different levels, you know, so you look at the worst alternative and the best alternative. The best one will be for you to settle, isn't it? If you are not able to settle through that, you go to court. You also look at your worst alternative and you look at what am I ready to do, walk away with. We didn't use those particular terms that explain them, isn't it? When you are going to a negotiation, you say you have your limit. Don't go beyond 250 and give up something like that. That is it. Worst case scenario, don't exceed this. Best case scenario, maybe if you have 250, you are just offering 100. Are we together? Yes. All right, thank you. Any other question on your vision?
Sorry, let me take clarification.
Yes.
I have a zeal and interest in the things of alternative this. So, like I started in there, I have the interest, I have the zeal for this alternative. But then the question is, as a judge, you know we have our ethics. Are there limitations for the judge to be really involved in so passionate in practice? And because from what I've been listening, the way I've been listening,
understanding is like you are encouraging us to take this in serious and if you comfortable as a judge, would it take a conflict with my position as a judicial officer? To make this clarification. Okay. Now, the director of the Transplant House has been a judge, isn't it? She is a member of Nigerian Institute of Chartered Arbitrators. It means when there is arbitration, they can appoint. She is a faculty member. It means she teaches. That's how she does here. Right? Now she is a fellow of Nigerian Institute of Chartered Arbitrators and Conciliators. If there is a mediation session, they can ask her to appoint that team. She is also a faculty member of ICMs. It means she teaches people to become mediators. Are there no sources of income? You can practice both, you can teach it, isn't it? And then she's a Mediation Training Institute Nigeria certified mediator. Does it conflict with what she does? No. If you have your session, mediation session, you will say do it outside of your work. You cannot sit in the office there and be doing your party. You cannot sit in your position as a giver negotiating for settlement, isn't it? So if people are appointing you, they are not appointing you in your capacity as a judge. They are appointing you in your capacity as what? As an area practitioner. The parties that are appointed will the house will appoint. When she is still sitting as a judge, the Montreal house appoint her. Sometimes they volunteer mediation, sometimes they do pay, like the last day I don't expect pay in person. Right? So when she does these things, she volunteers. It's not going to conflict with what you do. In fact, judges are best arbitrators. Why? Because they are already used to forming opinion about some things and writing judgment. And arbitration is more or less like that. You listen to the parties and you give your judgment is called an award. And you do perfectly well. There's no way to compete with the work you do, except when you come to your, when you are sitting, you start trying to say you settle people and say you are descending into the career. But if you have the way of separating these things, Thursday, that's the last day of the week for you. Friday, Saturday, Sunday. If they are going to even fix your mediation on Sunday or arbitration on Sunday, so it has nothing to do with the work you do. If you see, we have a lot of the former CJ. What's his name? Fellow. He's now a fellow of ICMs. They have been doing there that seat. If you go to most of the justice below that retire, all of them are fellow of Nigerian Institute of Chartered Arbitrators. Fellow is a fellow of Institute of Chartered Arbitrators and Conciliators. We have a lot of judges who are together. Are we together? So it has no way of thinking with what you think. It will enhance it. Enhances it. Are we together? Do you understand? Any other question? Okay. Are we together? Are we together? Any question? Any question? Okay, so we understood this part. Thank you very much. Now, the only thing that is outstanding and remaining is the practical session. Yes. Huh?
Online.
Okay, Hawa. Okay, please go ahead.
Hello. I can't hear anybody.
We can hear you. I can hear you.
Please go ahead. We can hear you.
Okay, so before she speaks, you know,
Okay, thank you.
okay, so before you will in, okay, you see, after your training, you're supposed to do an induction. You're supposed to do assessment and do an induction before your certification. Is this something you think you can do within this year? All of you. Is this something you can do? You are going to do an assessment. We will send you the questions. You will take your time to do it. No consultation with any other materials. You just use what you have learned to answer them. After that, if you pass, after that, when you pass, then you can be qualified for induction. We are hoping to do an induction in December. Let's say we are hoping for like 15 or 16 or any of those days, maybe 14, 15 or 16. Thereabout. So, do you think it's something you can do? So that if it's something we need to adjourn it to next year, according to your order. Or adjourn it to next year. Right? Okay, so you have the platform. We can continue the discussion in the platform. You do an assessment. If you do and you're able to pass the assessment, you'll be qualified for induction. And the induction, you pay a fee, your induction fee, and then that's for those who pass. Only for those who pass the assessment. You do your induction. After the induction, you become certified as mediators. So if it's something that you can do, I think the group is open now, right? The WhatsApp group is open. You can do a conversation. Let's have your opinion or what you have decided so that we can schedule those things and see how you can partake in it. So, Awa, can you speak now?
Hello?
Okay. All right, go ahead.
What I'm saying about it is, I think we can finish this assessment within short time.
We can't hear you. We can't hear you. We have been muted.
Howard, you want to say something? Okay, so the thing is, what we are doing, we want to give you the best. We want to give you our time. This is your training. And you have this training where they do visual skills and they give you opportunity to do practical. You have this. But that is the main thing. If you cannot translate what you have learned into practice, then you have a long way, isn't it? So if you are going to be around, we will just share you into script. What we want, even if you are going to spend little time, and the scenario is debt recovery. We want each person to play the role of the mediator. So if you do and you use like 5 minutes to finish a session, another person will take the role of the mediator to serve as party. Just have a test of how it feels. Are we together? As a party and as a mediator. And then at the end of it, I believe that you can be very confident even when you go out there. When you meet people who have been doing this, they will be wondering whether you have done it before because of the thing you have been doing it over and over, and the same thing you are going to go and meet there. It's just that the circumstances may differ. But what you have learned, you are going to use it and you'll be proficient. Are we together? Are we together? So is that okay with us? Okay, so if we are okay, we can just divide ourselves into three. Just three persons. 3. Okay, let's say 3 here, 3 here, 3 here. We have 3 groups. You can just pick your chair, just go 3. Hello, Howard.
Yes, I'm with you.
Okay, so it seems you are the only person online today.
Yes, I'm the only serious one. Yes, I am.
Okay, so what do we do? We'll come log in and discuss with the part of the session. We are going to, somebody will log in and then you do the session.
Okay, no problem.
Just one thing, I just stand there.
Okay. Good evening, ma'am. Can you hear me, ma'am? Doctorate, postdoctorate degree, postdoctorate degree.
She there?
Mrs. Howard, you said?
Yes, I'm with you.
Okay, ma'am.
Good evening. Yes.
Good evening. You want to make use of it, ma'am? All right, but we are supposed to work on the simulation debt recovery. Have you been able to go through it?
Okay, no, I can't see the scenario on the screen.
Okay, no. Are you on the platform? Are you on the WhatsApp group?
No, not yet.
Wow. Or maybe just send me your number. Just type your number on the chat so that I will add you to the WhatsApp group.
Okay, I will.
In the meantime, let me share screen. Okay, I've seen it. Let me add you to the.
Your passport.
Okay, I have to forward the simulation now to the platform. Did you receive any message now on your WhatsApp?
Come and stay in my office first. I'll rest, come.
Not yet. Not yet. Oh, but I tried adding you now. They said you are already on the platform. Okay, let me check. Is it a PDF? PDF sent on the platform? Yes. I should open it. Okay, let me open it. Have you sent it? Okay, I've given you the other one. I've opened it. I'm reading it. Okay. Yes. Okay, so the debt recovery. It's inside.
The meeting.
Yeah, he's taking a class. You have sent it down. Let me tell him that you're going. Yes, I'm done reading. I think it's the first part of the debt recovery, right? Ma, if you are done with the scenario, I'm done. Okay. So, um, let me. Okay, maybe you act as the mediator.
Why me?
You act as the mediator, then I'll just cover up to the other two parties because we're supposed to be three.
It's all right, no problem.
Yes. So debt recovery, we have Mr. Musa, Mrs. Musa, and the mediator now. Okay, if you are ready, please, you can go on. I'm waiting for you, ma. I don't know. You know, as a mediator, you have to introduce yourself just like we did. Do the needful then.
Okay. Good evening, everyone. My name is Barrister Hawaii Sayuti. I am the mediator appointed to adjudicate over your matter. I'm sure you were given, as in you gave your consent before I was appointed as your mediator. Hey God, oh. So one of the rules of the mediation is confidentiality. So be rest assured that everything discussed on this platform will not be taken out. And I'll give you time to talk. You should vent out you should just vent out. You understand? we'll have sections, and if we are unable to conclude our sections at this first sitting, we will adjourn. Thank you very much. Please feel free to talk. I'm going to be very, very unbiased, as I don't know any of you. So feel free. Thank you. I'm done with the introduction.
Okay, so okay, anyway, maybe you can start the other party since okay, I'll be Mrs. Musa, then you will be Mrs. Musa as well.
Okay, no problem.
So, since I'm Mrs. Musa, I'm the complainant because I'm the one that actually go to my lawyer so that they will take Mr. Musa to court. But we are advised to explore mediation as a last settlement. So, my name is Mrs. Musa, and you can address me as Mrs. Musa during the course of this mediation. Well, I met with Musa sometimes early this year, and she actually assured me of a business proposal. She gave me a business proposal that if I give him the sum of 4.5 million naira, that we are going to that is going to buy fish. That is going to help me buy. Okay, sorry for the breaking transmission. So I gave Mr. Musa the sum of 4.5 million naira, and that he assured me that with that amount of money, that he's going to help me set up a fish farming. And I gave him this money. After some time, he disappeared. He was nowhere to be found for about 1 month. And then when he eventually succeeded, he did not bring the materials for the fish farming, but was only giving me one excuses after another. So me, I'm not happy about it at all, because he assured me and promised me that once I provide the sum of 4.5 million, to help me secure all the materials within 2 weeks, and that within the first 1 month of starting that business, I'll be able to refund a substantial part of that money, because it's a loan that I collected from the bank. And they are going to be charging me 10% monthly, 10% interest monthly, on a monthly basis. They are charging me 10%. And now look at the situation. I have collected the 4.5 million from the bank. Mr. Musa is nowhere to be found. And when he came, he started giving me one excuse after another. The money is nowhere to be found. And this is almost 1 month. The interest is going to start with. So that is why I said I wanted to take this matter to court so that I will recover my money. I was advised that I should just try mediation using Settlement House ADR Training Institute. So that is why I'm here. Thank you.
Thank you. I heard you. You said Madam Musa and Mrs. Musa. Are you couple? Are you couple, Mr. and Mrs. Musa?
Oh no, they are not. I just met him. We are not related.
Okay. So, Mr. Musa, what can you say? Okay, I'm the Mr. Musa. Voila. I'm the
Oh, good
mediator,
afternoon.
Mr. Musa.
Okay, now I've gotten somebody that helps me, Mr. Musa. Let him come and say it. Oh, he's very It's also a
Please let him
particular.
do
So
the Mr. Musa.
I've
It's
narrated
better.
my own part of the story. Let him narrate it. So now,
Okay.
okay. Well, good afternoon, good evening.
Good evening.
Yeah, I'm Mr. Musa.
Okay, welcome, Mr. Musa.
Yes, it's a pleasure.
Yeah, welcome.
Let me briefly state my own position.
Okay, I'm all
Yes.
ears.
So what happened is I asked Mrs. Musa, she told me that she did borrowed loan of 5 million from Economic Bank.
Okay.
So yes, we have had this, we are friends, and we're interested in the business progress of one another. Time to time like that, we engage in business, share ideas, you know. So it's based on that, friendship that I, when she told me she borrowed 5 million, she was seeking for ideas on how to go about using the said loan. So I now told her,
Yes.
because I'm proficient in fish farming
Okay.
and I've been into the business for over 20 years.
That's interesting.
Yes. So we know the nooks and crannies of the business. So what happened was I told her, in order not to completely collect the whole sum from her, at least she should have something. I said she could advance the sum of 4.5 million
Okay.
to me. And
Yes.
looking at the business atmosphere,
Yes.
there's that prospect of, when I go into this fish farming, we're able to realize that capital within a short while.
Yes.
And then for the first, since the interest payment is monthly, we'll be able to pay the interest within a short while, because we have to buy fingerlings and then feed with the fish
Yes.
altogether. So what happened is I usually go to the feed itself is being supplied from Maiduguri and then Kano to Kaduna. Sometimes if I don't
Yes.
get it in Kaduna, I'll get it in Maiduguri. That's Borno State.
Yes.
So what happened was, this particular time, there was a little complaint that the materials that are used in making the feed is not
Yes.
available due to bad business, bad weather, the weather
Okay.
condition.
Yeah.
So I advanced that sum of usually I advance 4 million, rather 4 million to them. So that when they supply it, I'll now give them 500,000. I don't just want to give them the total sum, but at least
Complete money.
substantially. Yes,
Yes.
substantially, because they will have to go make order, and then the transportation, that shipment, all those things are involved, and the risk, all other things.
Yes.
So what happened? I now told them, so when will I get this? Because this money was a borrowed money, and I have to be servicing the loan. The person that borrowed has to be servicing the loan
Yes.
on a monthly basis. And looking at this situation, that they didn't end up, sending those materials, and then the fish that I
Yes.
need to
Wow.
start it up based on our agreement with Mrs. Musa. Now they're having some issues. So how soon will I be able to get the feed and then fingerlings too? So they now told me that, honestly, hello,
I'm with
hello.
you. I'm with you. Yes, I'm with you.
They now explained to me that it will take 1 to 2 months.
I'm with you,
And
but
this is,
you are still
yes.
the
So this is the situation. This is the situation. I want Mrs. Musa, I explained it to Mrs. Musa, but she is not patient, because she said that this was not the agreement, that
Yes.
we agreed that within this short while I'm going to pay, give her pay back the money, so that she can be able to service the loan by the monthly interest
Okay.
payment. So that's the situation now. If only she can be patient, since this is not something deliberate, this is not something that I envisage. If she can be patient for that 1 to 2 months, then
Patient
we can
till
be able
when?
to.
If she can be patient till when?
Now we are in October, November 25th.
Yes.
December 5th. Let me say first week of February.
First week of February.
January.
January. Mrs.
Yes.
Musa, are you there? Can you hear him?
Yeah, I can hear him. Me, I don't understand what he's saying. Me, I just want this money because this story he's telling, I gave him this money and he disappeared into thin air. And now he's
I
coming.
understand. I
So me,
understand. I
I just
understand,
want my
Mrs.
money.
Musa.
I
I
just want my
understand.
money because
You know, I'm
okay.
I'm only here to guide you people. I'm not here to give you directions on what to do and what not to do. So please, I need the both of you to come to an understanding with yourselves, please. I'm sure you heard what he said.
I heard him.
What can you do for him in this situation?
It's actually a difficult situation because the interest has started reading in the
Mrs.
bank.
Musa, note that everything we do here is going to be endorsed and it can be used. We are going to document it and it can be used as evidence in court. But me, I can't serve as a witness for you in court. But you write an agreement to that effect.
No, for me, I thought
Whatever.
they said the mediation process is confidential. So me, I don't understand this part you are talking about using. They said they assured me that whatever we are saying is confidential and private.
Yes, that's what I'm telling you that if he's going to document it, we are going to put everything in writing. That's what I'm trying to tell you. He's going to we'll repeat our sayings into writing. That's what I'm saying in essence. So what can you do in this situation? Do you agree to
No,
what he said,
me,
or
I'm
what do you
feeling
want?
uncomfortable now. It's not because of anything, but if I thought they said that even if you document these things, at the end of the day, you share it. It's not going to be, except maybe if the judge calls you of court when it, or maybe if you are
Yes,
filing the terms
that
of
is what I'm
agreement.
trying
Me,
to
based
tell
on
you,
what I
that
read, that's what
that is that is what I'm trying to tell you, that should in case what he says is no go by it, you can use these documents when asked for in court. Should in case, I'm not saying that you are going to do it immediately. You
I
understand?
understand.
So please,
I understand.
what can you say?
I don't know. I wish I could just get that money. But with what he's saying, honestly, if I'm going to agree with what he just said, he's saying
Yes.
this month, November already is 1 month. I gave him this money since October, and it's 1 month.
Yes.
And the interest, 10% interest rate from the bank starts reading from this month. So
Yes,
if
I
the
understand.
only way I will accept what he's saying is if we're going to share the cost of the interest, 50-50%. If he's
It's all
saying he
right.
will cost and then
Malam Musa, are you there?
Yes.
Can you hear what she's saying?
Yes. So in
You can
essence,
hear her.
yes. In essence, she's interested in the interest payment for the months that have passed.
Yes, that you should share it 50-50. That you should
Okay.
share in the repayment of the interest 50-50. Do you agree with her?
Yes, provided she can wait for that period that I told her, pending when
Yes.
those persons.
Yes, that's what she said. She said if you agree to share the interest with her, because the interest starts from this month.
Well, if that's the
Did you
case,
understand? Pardon?
I understand that. I understand her.
Okay,
I
so
know how difficult it is. So, if that's the case, since she's willing to concede for me to wait for me for that period that I asked,
yes.
no problem. Let's share the interest, at least knowing that, so that she will not be totally at a loss too.
Okay, thank you very much.
I'll be willing to
Mrs.
concede to
Musa.
that.
Mrs. Musa. Mrs. Musa.
yes, ma'am.
Hello, Mrs. Musa, are you there?
Yes, I'm here.
Do we have a deal now?
Yes, ma'am.
Thank you very much. About my professional fee, you said
Okay.
until we are done. Yes. My charge is 2 million.
Okay, we'll play one now.
Sorry, sorry. Sorry.
Yes, yes.
Sorry, I thought you are affiliated to Shati. ADR Center.
Yes, I'm an accredited ADR officer, but nevertheless, they pay filing fee and all those fees. So while Mrs. Musa said she doesn't have the money now, that we should please wait when the procedure is done, as in after the process, that we should talk about she's going to pay, since the two of you are supposed to share in the payment of the professional fee. Yes.
But I have an observation or objection.
Okay.
Yes, that fee is too high because based on the charges, I think 200,000. I had 200,000. I think it's
No,
200,000 that they hit it
I
to.
don't know which settlement house or mediation house you belong to that you heard that, but in our own Shanti mediation house, usually we charge 10% of the monetary claim. We charge 10% of the monetary claim, but because I know there is a debt recovery stuff and you don't have the money, and that's the reason why I don't even charge 10%. 10% of how many million is involved? You're talking
4.5.
about
10% is 450,000 now. It's not 2 million.
10% is 450,000. 10% of 4.5 million.
4.5. Yes.
Okay, you know 10% is after the 10%. No problem, no problem, no problem. We are learning. Okay, that's all. Below is my account details. I'll be expecting the pay.
Okay. Okay.
Thank you.
Okay.
Thank you.
So,
Enjoy your day.
At least I didn't concede to
The
that 2
matter is
million.
hereby adjourned to the matter is adjourned to 2nd week of January 2024.
Okay, 2nd week of January.
Yes.
Okay. So thank you.
Thank you. Bye
Okay, I think we are done. Wow. We are
Yes, we
done.
are done. Yeah.
So we'll send your money
Yes, so send it.
when the fish everything comes here, Martina will send your money.
Okay, no problem.
All
Thank
right,
you,
now
ma.
we're also done with the training here. So I
Okay.
think you can log out. The other
It's
information
all
to be
right.
sent on the platform.
It's all right. Thank you very much.
All right, bye
Bye bye. Mm-hmm.
bye.
Have you said to them? You are on it, okay, let's go to the other side. So that you can in November.
So we thank you for attending the session from the beginning to the end and for the practicals which have been conducted. We believe that you have learned sufficiently. See you. We can continue our conversation on the training platform. Thank you. And remember this.